Great, thank you.
Thanks.
Well, that was a good job today. We need to do it again tomorrow. I mean, next week.
What? The alternative. He just said the same thing.
Like David Trump or something. He used to be against it. Chuck Robb says, I don't know. All that stuff that you says. Good, but there's no alternative. Yeah. There was one. Good show. Thank you.
Stand here a second in front of Senator Grassley, the thinking senator with his hands up like this. Where are you, General? Right here. This is the last happy group of Okay. I think you got it going. These envelopes that say Joe Biden on them, no identification.
All right.
Good luck.
Good luck to you. Oh, yeah.
Look at the pen. Milwaukee Bucks. Wait. Maybe a little bit. Thanks.
What happened to our nominee?
See, Mr. Chairman, you let these guys in the well farm for a change and look at them. They just stay there, they don't move. Thanks, fellas. Before we begin the hearing, I want the record to show that
Last night I attended a basketball game of the Milwaukee Bucks versus the Philadelphia 76ers. And there were, as a consequence of the generosity of the senator from Wisconsin, who has a mild interest in the Milwaukee Bucks. And I must say I was publicly embarrassed because as he was listening to the game heading home, apparently the announcer said, and there's Senator Biden rooting for the 76ers. And he has just presented me with a pen, the Milwaukee Bucks. I'll try to do better next time, Senator, but thank you nonetheless for accommodating my ability to see the game.
Is that an endorsement?
That is, well, yes, it's an endorsement in Wisconsin. Anyway, and it's always easy to endorse Senator Cole. Well, welcome, General. It's a pleasure to have you here. It's a delight to have you before the committee, and I'm sure you're delighted that we're finally reached the point that we're here. You know this committee well, and I've enjoyed our work together when you're in your previous incarnation, or you're present. Well, you're the acting now, but your previous incarnation. And I look forward to us being able to continue to work together. You know the process. I have an opening statement. I'll invite my colleagues if they have brief opening statements to make, and then we'll invite you both to introduce your family and make an opening statement, and then we have some questions, if we may. Today, the Judiciary Committee opens its hearing on the nomination of William Barr to be Attorney General of the United States. The office of Attorney General is unique among the President's cabinet. The Attorney General is a member of the President's administration, but his allegiance is not to the President alone. As the nation's most senior lawyer, the Attorney General's oath of office to defend the Constitution and to faithfully execute the laws of the land takes on a special meaning. His commitment to that oath may not be compromised, even in the name of serving the President of the United States. To put it another way, the Attorney General is not the President's personal lawyer. That role is served by the White House counsel. The Attorney General is more properly considered the people's lawyer. His allegiance must be to the public. He must protect and enforce the rights of all Americans. Of course, the Attorney General serves the President in many ways, and among others, he advises the President on the constitutionality or legality of proposed actions or policies. He assists the administration in determining what positions the government will present in federal courts. And he directs the Department of Justice in serving the legitimate goals of the administration in all law enforcement matters. But he must also be prepared to tell the President, in my view, that a proposed course of action would violate the Constitution or the laws of the United States, even when that advice is not what the President wishes to hear. In short, while working to serve the President, the Attorney General has a unique responsibility to the public that requires him to maintain independence from the President's personal and political interests. Fulfilling one's duty to the President without surrendering the necessary independence presents a dilemma for every Attorney General, and it has presented a dilemma for every Attorney General in the past. Understanding that the competing responsibilities must be carefully balanced is one of the most important attributes an Attorney General, in my view, can bring to this job. It is my opinion that in recent years, the Attorney General and other senior officials within the Department of Justice have not always found the proper balance between these two competing interests. There has been a tendency, in my view, to blur the distinction between the role of Attorney General and the Justice Department on the one hand and the White House counsel on the other. The country, in my view, is best served when these roles are clearly delineated and purposely separated. The rule of law is best preserved in this nation when our Attorney General is dedicated to the law first and the President's political agenda second. As a result, in these hearings, much of my focus will be on whether or not how Mr. Barr views the proper relationship between the Attorney General and the President. This issue is a particular concern to me because during his years in government service, Mr. Barr has gained the reputation as a staunch defender of broad executive power. And as indicated to you earlier, General, I'm going to want to talk to you about that. And I say that, by the way, not as in any way suggesting you've compromised anything, just your philosophic view of the role of the executive and the Congress, because if your reputation as being such a staunch defender of broad executive power is deserved, and that is a matter to be determined in these hearings, Mr. Barr may be sympathetic to efforts of the current administration to enlarge and consolidate the power of the executive with an accompanying disdain for the legitimate role of Congress as a co-equal branch of the government. Because the Attorney General's preeminent responsibility is to uphold the Constitution and enforce the law, he must adhere to the Constitution's division of responsibility and power between and among the branches of government, whatever his own ideological view or those of the President's may be. Mr. Barr, in these hearings, I will ask you about several areas where the Constitution's division of power between the Congress and the President has caused some tension. For example, I'll seek your views on the war-making power, on the independent counsel statute, and on the veto power, and on the judicial nominating process, among other things. And I suspect you'll get questions from me if I have a second round, if they've not been asked already, about the Justice Department's handling of the BCCI matter as well. I will also ask you about several areas relevant to the Attorney General's role as the nation's chief law enforcement officer. This committee and the Attorney General each bear responsibility for the shaping and implementing of the nation's crime policy. So your intentions with respect to fighting the war on crime and your role in directing the Department's handling of criminal investigations are of great interest to me and to the committee. Mr. Barr, you appeared before this committee twice before, each time winning confirmation of the position within the Department of Justice for which you were appointed. As Deputy Attorney General, and more recently as Acting Attorney General, you have had substantial contact with this committee. And from my personal perspective, the contact has been harmonious and you have always been cooperative. We welcome you back and we look forward to discussing the issues I've mentioned and others with you in the course of these hearings. And it is my hope and intention that we will be able to finish these hearings in a timely manner and let the Senate work its will on your nomination. Again, welcome, and I now yield to my colleague from South Carolina.
Thank you, Mr. Chairman. This afternoon, we begin the confirmation hearing on Mr. William P. Barr, President Bush's nominee to be the Attorney General of the United States. The position which Mr. Barr has been nominated is one of the most important in the federal government. The Attorney General is the chief law enforcement officer of the federal government and has ultimate responsibility in regards to major civil litigation involving the United States. He also gives advice and provides legal opinions to the President on a wide range of issues. The Attorney General manages some 88,000 employees nationwide and oversees major components of the Department of Justice, such as FBI, DEA, INS, U.S. Marshal Service, Bureau of Prisons, and U.S. Attorneys. The person entrusted with this grave responsibility must perform the duties of this office in an independent and uncompromising manner. I am confident that in Mr. Barr, we have a nominee who demonstrates all the fine characteristics an Attorney General must possess, namely integrity, good judgment, competence, courage, professionalism, and independence. I believe Mr. Barr understands the importance of this position, having served as a Deputy Attorney General and more recently as the Acting Attorney General. His service in these positions has clearly shown that he will continue to ably perform once confirmed. Mr. Barr has demonstrated he can make tough decisions. It was this nominee who, as Acting Attorney General, orchestrated a pre-dawn prison rescue that freed 9 hostages with no loss of life. Mr. Chairman, Mr. Barr's background and experience will serve him well in this position. He received a Bachelor of Arts degree in 1971, a Master's degree in 1973 from Columbia University. In 1977, he earned a law degree from George Washington University Law School. During law school, Mr. Barr served in the intelligence section and officer of Legislative Council of the Central Intelligence Agency, after which he served as a law clerk to the Honorable Malcolm Wilkie of the United States Court of Appeals District of Columbia Circuit. From 1978 to 1982, he was an associate with the law firm Shaw, Pittman, Potts, and Trowbridge. Mr. Barr then served as a Deputy Assistant Director, Office of Policy Development in the Executive Office under President Reagan. He rejoined the law firm of Shaw, Pittman, Potts, and Trowbridge as a partner in 1983. In 1989, Mr. Barr was nominated and confirmed as Assistant Attorney General for the Office of Legal Counsel in the Department of Justice. In 1990, he was confirmed as the Deputy Attorney General. President Bush has now nominated Mr. Barr serve as the nation's chief law enforcement officer. Mr. Chairman, Mr. Barr is an individual with vast experience, thorough understanding of our system of government. He realized the importance of the role of the Attorney General and the responsibilities that would be imposed upon him. I believe he will give competent advice and fair opinions to the President on all issues that may arise. And he will be ever mindful of the trust and confidence placed in him by the President as he carries out the duties of this esteemed office. And Mr. Barr, you would be congratulated on your nomination to this important position, and I look forward to hearing your testimony. Thank you, Mr. Chairman.
Thank you. I join in welcoming Mr. Barr back to this committee and commend him on his nomination to be Attorney General, and join in welcoming his family here today. The Attorney General of the United States is a symbol of American justice and one of the highest positions of public trust in the land. And all of us look forward to a close and cooperative, constructive relationship with the Department of Justice under his leadership. And as our nation's chief law enforcement officer at a time of scarce resources, Mr. Barr will face a unique challenge. We've not done enough over the past 20 years to equip law enforcement officials for the task of fighting crime. The tens of thousands of Americans who fall victim to crime each day know that more must be done. And the criminal justice system is bursting at the seams, causing prosecutors, courts, judges, and prisons to call for more help. And thousands of offenders convicted of serious crimes are released too soon because our system is overloaded. Today, 1 million offenders are in prison and 2.5 million more are free on probation or parole. Getting tough on crime means equipping our criminal justice system with the resources and tools it needs to put criminals away, and it means having enough officers on the streets to apprehend criminals. And it means having enough federal and state prosecutors to deal with offenders, enough judges and court personnel to conduct trials, enough prison cells, not just cots in the desert, to incarcerate those who should not be free to roam our communities. Finally, it means investing in programs that are genuinely capable of preventing crime. To build a new prison costs the federal government as much as $85,000 per inmate. A place in a Head Start facility costs 5% as much, and it cuts the teenage arrest rate by nearly half. It's penny wise and pound foolish for Congress and the administration to spend vast sums for new prison cells and refuse to allocate a small fraction of that amount for new places in preschool classrooms. Mr. Barr comes before this committee with a distinguished record of public service in the Central Intelligence Agency, in the White House, in the Department of Justice, as well as in the private practice of the law. I look forward to his testimony this afternoon. I congratulate him on his nomination, look forward to working with him in addressing these issues that are so critical for the future of our society. Senator Hatch.
Thank you, Senator Kennedy. In William Barr, and I welcome you to the committee, Mr. Barr, President Bush has nominated a tough law and order public servant to be Attorney General. Just as important, Mr. Barr is firmly committed to equal opportunity under the law. He demonstrated that again last week when he initiated administratively a fair housing testing program at the Department of Justice to combat housing discrimination. And I was especially pleased to see the department undertake this program as a response to legislation that I introduced in the last two Congresses. At the same time, I am confident that Mr. Barr will be equally vigilant in opposing racial, ethnic, and gender preferences and reverse discrimination. William Barr is not a member of President Bush's political or personal inner circle. He is not part of the President's political brain trust. He is not a politician or a former politician who brings political clout to this position or carries political weight in one of the 50 states. William Barr is just a lawyer's lawyer. That's all. President Bush's nomination of Mr. Barr is one more example that persons with talent and merit can and do rise to the top of our country. Talent, merit, and performance are the only reasons William Barr sits before us today as acting Attorney General and as nominee to become Attorney General. So I commend the President for this fine nomination, and I congratulate you, Mr. Barr, for your sterling record. After 2 degrees from Columbia University, William Barr went to work for the Central Intelligence Agency, attended law school at night for 4 years, and obtained his law degree from George Washington University. And after clerking for Judge Malcolm Wilkie of the U.S. Court of Appeals for the District of Columbia, He became an associate at Shaw, Pittman, Potts, and Trowbridge here in Washington. And for a year and a half in the first Reagan term, Mr. Barr served as Deputy Assistant Director of the Office of Policy Development. And I hope I will not embarrass Mr. Barr when I pause to marvel at his rise from a relatively obscure federal position to this nomination 8 years later to the #1 legal position in the executive branch. And this rise is nothing short of phenomenal. In between, Mr. Barr became a partner at his former law firm. He was tapped to become Assistant Attorney General for Legal Counsel in 1989. I have to say his performance there merited his promotion to Deputy Attorney General, and his conduct in that office has continued to be impressive, and he is now before us as the President's nominee to become Attorney General of the United States. Will he be tough enough when the situation calls for it? As Acting Attorney General, faced with an inmate uprising and hostage-taking at a prison in Alabama, he exhibited sound judgment, courageous leadership, and took the tough action that was necessary when the chips were down. I will close by quoting from an unlikely source, the New York Times editorial page, because it had some kind words for Mr. Barr. Here's part of what the October 20th, 1991 editorial said. William Barr is an able and energetic lawyer who has already displayed strong loyalty to his client in the White House. In various high-ranking Justice Department jobs, he has boosted the administration's hardline crime legislation and endorsed its view of executive power, unquote. Perhaps the New York Times viewed this latter comment as a criticism, but I regard it as a compliment. The editorial continued in part. As Acting Attorney General this summer, Mr. Barr made key decisions under pressure that led to the rescue of hostages in the uprising at the Talladega prison in Alabama. He impressed Mr. Bush as much for not grandstanding as for firm leadership. Mr. Barr has also impressed many in Congress, even those who disagree with him, for his forthrightness. So I congratulate you on having this great opportunity. You've earned it. I think you'll make a great Attorney General. I know that you'll give sound advice and that you'll have good judgment backing up that sound advice, and I don't know what more you could ask for in this particular important position in the executive branch of this government. And I think the President has made a wise and a very good choice in picking you for this job, and I look forward to seeing you confirmed.
Senator DeConcini.
Thank you, Mr. Chairman. Mr. Barr, welcome, and your family. We're pleased to have you here. If confirmed, Mr. Barr, you'll bring a considerable amount of government experience based on your background and working in the government. I think that's very positive. And from all indications, it appears that you have done a good job in all of these positions, being confirmed here before unanimously with little or no debate. But because of the importance role that the Justice Department plays in enforcement of this country's laws, I have always been a strong believer that the Office of Attorney General should be as nonpartisan as possible. I realize the political aspects and reality of our system here, but nevertheless, that's my own feeling. In my mind, the nominee for Attorney General has to be able to demonstrate the ability to exercise nonpartisanship in carrying out the duties of that office. For not only is he the Attorney General that the President may call on, and the lawyer's lawyer, as Senator from Utah says, but he is the chief advocate for the rights of all Americans. And as such, there should be little room for politics. I hope that you realize and understand the political ideology cannot be substituted for fair and effective law enforcement. In many respects, the Justice Department is one of the most important agencies in the federal government, in my judgment. If confirmed, you will serve as the country's chief law enforcement officer. It will be your responsibility to work closely with your law enforcement counterparts, not only in the federal government, but in the states and local governments as well. You and I have spoken, Mr. Barr, before at great length on the need for improved cooperation in our law enforcement efforts. And over the last few years, federal law enforcement efforts have been greatly hampered by the inability of federal agencies to work together, at least in my judgment. And how can we win the war on drugs, defeat organized crime, and stem the growth of violent crime in our communities if our own law enforcement agencies are battling amongst themselves? Well, we can't. And in my judgment, we are not. The bottom line for this senator is whether you will be able to take the lead in bringing these agencies together in a united effort to protect our citizens. You've spent many years in the executive branch, and I know you are well aware of the turf battles that are there on a day-to-day basis. That is why I hope that you are a nominee who will take positive steps to eliminate these interagencies battles, not aggravate them. I hope to pursue this issue further during the questioning, and I am interested in hearing your ideas on how you would address this problem. I know you've had experience with it. The spirit of cooperation must extend to the states and local governments as well. After all, it is the men and women in uniform who patrol our streets and highways in our states who are the front line of our fight against crime. They rarely have the support of the federal government except when there is a personal relationship developed on the local level. The local police and sheriff department cannot be left to swing in the wind by the Justice Department. Instead, they must be able to look to the next Attorney General as a partner in the war on drugs and against gangs. As Attorney General, you will be responsible for the administration of the number of law enforcement entities, each with a distinct mission. For some time, I've expressed my concern that one of these agencies, the U.S. Border Patrol, has been neglected by the Department of Justice and treated as a stepchild, despite its role in the war on drugs, especially along the southwest border. The Border Patrol is an agency which is woefully understaffed and ill-equipped to perform its own mission. You don't win a war without deploying all the resources, and we have done an embarrassing job in respect to the Border Patrol. As it is, they are responsible for nearly 60% of all drug seizures along the U.S.-Mexican border and serve as the lead agency in the interdiction of narcotics between the ports of entry. The job they do with the resources they have been given is quite remarkable, but something has to be improved. I hope to get some assurance from you, Mr. Barr, that this issue will become a priority and that at last the Border Patrol will achieve the attention it deserves from the Justice Department. And the next Attorney General must work to restore the public's confidence in the Department role in protecting their rights. It appears to me that you fully understand the importance of this position, and from what I can see, you were chosen for your competency and not for your ideology or your political background. We need an Attorney General who can take a position that his or her president might not like, but that the law requires, and give that kind of advice. I look forward to your testimony, and we'll have a number of questions to address to you, Mr. Barr. Thank you.
Senator Grassley.
Mr. Barr, it seems to me like you bring a distinguished record of public service before this committee today. You seem very well suited for your newest challenge. I think you have a very impressive career in a series of high-level positions in the Justice Department. The fact that you've been confirmed by this committee and the Senate twice before, I think is important as well. I remember as Assistant Attorney General, you're being in charge of the Office of Legal Counsel. Here you gave the President objective advice as to the legality of various important public policy proposals. And I especially remember that despite the fact that President Bush and many members of this committee would have preferred that for reasons of policy, the Supreme Court's flag-burning decision could have been overturned by statute, I know that you stuck to your conclusion that a constitutional amendment would be required. You've also served with distinction as Deputy Attorney General, bringing into that office at a time when morale was in the department was not so high, a leadership that was badly needed. Your performance in that job was so successful that when the position of Attorney General became vacant, President Bush nominated you to be acting Attorney General rather than waiting to name a permanent replacement. Also, I think of the time that prior to your work, serving in various capacities in government with the CIA and the White House as preparing you well for your job. The fact that you had to work hard attending a law school at night, practicing law in the private sector before coming to the Justice Department, all bringing you bringing a great deal of diversity of legal experience to this new position. The President's confidence in naming you as acting Attorney General is well justified. For as acting Attorney General, you have shown outstanding leadership. 3 days in the job, you faced that major crisis at Talladega with the federal prison there. You didn't avoid taking risks to protect your chances for the job that you now hold, nor did you take any unnecessary risks with the lives of the hostages with the hopes of advancing a career. You acted decisively and responsibly to maximize chances for success in freeing the hostages without causing death or serious injury. And of course, in this respect, all that you did was successful. In short, I say that you have all the makings of a great Attorney General at a time, and particularly I say this because it's a time when public officials are not held in high regard by those the public that we serve. So I hope that your being appointed to this will serve somewhat as an antidote to cynicism and to distrust. You're a capable administrator, and I believe, from what I've read about you, to be a wise counselor. And these are two important roles that you must fulfill in your new position. So I'm confident that you will continue to pursue the important work of the Justice Department as you become our nation's Attorney General.
Senator Leahy.
Thank you, Mr. Chairman. Mr. Barr, welcome, and you and to your wife, and I might say 3 very patient, very lovely daughters, but extremely patient with us. I find this an extremely interesting time with your nomination, and I hope it is an indication of a change from, frankly, from your 2 predecessors. You know, the next Attorney General is going to confront some great challenges. And today, the most serious threat to our nation isn't from a superpower thousands of miles away, but it's from some very grave crises here at home. While crime threatens our safety, even in our own home, children are killing and being killed in wars over drugs, the administration has talked tough. I'm not sure it's done a great deal. Major scandals like BCCI have not been pursued. They appear to be swept under the rug. Meanwhile, the Justice Department, well, these things are not being taken care of, doesn't hesitate to move very, very quickly to undercut the authority of a federal judge in Wichita. It tries at every turn to eviscerate privacy rights, has gone as far as to prohibit doctors from providing full health care information to poor women. And when we should have been going after drug kingpins, the Justice Department used its resources to snoop around libraries to see what people were reading. Considering what our educational scores are these days, we ought to be encouraging people to read, not sending the FBI around to see what they are reading. Now, in light of these failings, a lot of people question whether the federal government can deal with the problems at hand. And after too many scandals and one special counsel investigation after another, the public trust is no longer a given. The Justice Department has to earn back the trust of the people by enforcing the laws, as simple as that, fairly, evenly, vigorously. The Attorney General has to respect our constitutional rights of all of us. He has to pursue the haves and have-nots with equal vigor, the white-collar criminal as well as the poor, the drug trafficker as well as the user. The American people understand the symbolic tough talk, gestures like a federal death penalty for gas station murders or a suspension of habeas corpus. These are merely diversions from a losing battle against crime. And the symbolism erodes confidence in law enforcement. And throughout the country, there's despair for the cop on the beat who is fighting a hopeless battle, disdain for the judge behind the bench who couldn't possibly keep up with the docket, outrage at political leaders who claim victory by ignoring blatant reality. And this loss of faith in the fair enforcement of the law means loss of faith in the legal ties that bind up our society. The greatest challenge for an Attorney General is to inspire confidence in the public, the Congress, the court, and the President. Each will expect something different from you. The public's going to demand that you justly enforce federal law. The Congress that you remain independent. The court that you preserve your integrity and uphold the Constitution. And the President that you serve as his confidant and advisor. You're going to have to balance yourself on a very difficult fault line in between. If confirmed, you, more than any single individual but the President, is going to have to grapple with these problems. To do the job well, you're going to have to remain objective. You have to rely on the professionals who work for you. You have to resist pressure to make the Department of Justice an outpost for the political agenda of the Republican National Committee, not the easiest thing in the world to do in a presidential election year. Now, there are a number of issues I'm going to discuss with you during the hearing. First, incidentally, let me join with those who have commended you on handling the Talladega hostage incident. We've discussed this in private, and you know the high regard I have for your handling of that. Your judgment and willingness to make a tough decision during that crisis were exemplary. But there are other matters of concern to me, including the Department's handling or mishandling of the BCCI scandal, Justice's unwise involvement in the Wichita Operation Rescue matter. I want to know your views on judicial nominations process and other criminal and constitutional, even some technological issues. And as we've discussed before, I'm particularly concerned that the Justice Department moved beyond a partisan, unresponsive approach, one that has taken to the Congress and this committee in particular in the last few years. You may recall I made a couple comments about that on your first hearing here as Deputy Attorney General. Your predecessor, former Attorney General Thornburgh, viewed the Congress as a nuisance. And when he appeared before the committee, he made it very clear he had something more important to do than talk with us. So the burden is going to be on you to establish a constructive working relationship. I want to be responsive, accessible to members of Congress, could even break with tradition and respond to letters from Congress. And if you assume control of the Department of Justice, you do well to remember Justice James Iredell's assessment in 1792. He said the Attorney General, and I mentioned this because of a comment made earlier by one of the other senators, the Attorney General is not called the Attorney General of the President, but Attorney General of the United States, all of us. So whether you're that rare public official who is dedicated to the job rather than the individual who appoints you, or a footnote in history, like your immediate predecessor, that's going to be up to you. The country needs, I mean this seriously, the country needs a person of strength and dedication who's going to serve all Americans. The Attorney General probably as much or more than anybody in the whole cabinet is supposed to be there for all of us, Republicans, Democrats, conservatives, liberals, moderates, whatever. And I hope for everyone's sake that you are that person. You have all the background to be that person if you want to be. And it's going to be entirely up to you. Thank you. Thank you, Mr. Chairman.
Thank you very much. Senator Simpson.
Mr. Chairman, I thank you very much for holding this hearing swiftly to accommodate the President and put the Attorney General in place before we recess at the end of this month. And I welcome the Acting Attorney General to the committee and his wife, Christine, and the three delightful daughters, Mary and Patricia and Margaret. Very patient there, I think. Indeed, you are. And just a comment or two. While many, I think, of us here on the committee and in Washington are aware of this point, I think that observers of this committee should see that executive branch appointments differ greatly from nominations to the federal court system. But as you can see, there's plenty of partisanship left over for this one, too. But federal judges derive their power from Article 3 of the Constitution, which describes the federal judiciary, even though the President, who derives his powers from Article 2 of the Constitution, nominates judges. Once the judges are confirmed, they are interdependent and independent of the President. In contrast, the position of Attorney General is a position within the executive branch. That is what it is. The Attorney General may be fired at will by the President. I think people may not understand that. He serves at the President's pleasure. Thus, the Attorney General derives his powers, which are grounded in Article 2 of the Constitution, from his appointment by the highest authority in Article 2, which is the President. And therefore, Attorneys General and other executive branch appointments are not really intended to be impartial. the way a judge is required to be. Instead, they are supposed to put into effect the program of their president. I did want to make that distinction clear to some who have observed the committee and previously considering a judicial nomination. We are not looking for judicious impartiality in Mr. Barr. Instead, we're looking for an honest and capable person who will fairly and effectively advance the programs of the president. That has been the history of the job, Democrat and Republican alike. Mr. Barr, your presence here is a testament to your wise and careful and judicious handling of the management of the Justice Department. It is not often, as others have said on this panel, that a young and relatively unknown acting Attorney General is chosen over more senior and well-known figures in the legal community to become the President's lawyer. And over the years, those people have consisted of the President's campaign managers, personal attorneys, down through the ranks of Democrat and Republican presidents. You have been selected in this case as a singularly different basis than many of the Democrat and Republican senators or presidents who have gone before, because this president has the utmost confidence in your judgment, your intelligence, your capabilities, your prudence. Your professional record is exemplary. A master's degree in Chinese studies, service in the Office of Legislative Counsel, L.A. I won't go into those. Those have been covered. Ask those to be included in the record.
Without objection, they will be.
You have appeared before this committee twice before. You were confirmed without opposition to be the Assistant Attorney General for the Office of Legal Counsel. You were later confirmed without opposition to be Deputy Attorney General. And I believe that speaks to your qualifications and your abilities, which all of us on this committee have recognized. So I look forward to hearing your answers to our questions. I've heard the discussion of BCCI come up several times, and let's go into that. I want to do that too. I want you to tell them about the convictions in Tampa. I want you to tell them about the second round. I want you to tell them about the people who were in the clink and that were put there while you were involved there. I'm confident that you will show us that President Bush has chosen a very good man for a very tough job. I thank you, Mr. President.
Thank you very much. Senator Simon.
Thank you very much, Mr. Chairman. First, I think that as Attorney General, you can have a very good relationship. As my colleague, Senator Leahy, has indicated, I think a better relationship than with your two predecessors. I agree with Senator Simpson that the President has chosen someone who is honest and capable. I disagree with my friend Senator Simpson, however, when he refers to you as the President's lawyer. The President has a counsel in the White House. You are the lawyer for the people of the country. And we want you to always remember that. You serve in the President's cabinet, you serve at the President's will, but you are not the President's lawyer. You're the lawyer for all the people in this country. And I think on the basis of what I have seen from you, the people are going to be well served. Let me just add one other area where Senator Simpson and I would agree, and that is you are a person who's willing to dig in and work on legislative changes that are needed. I recall particularly one night, sometime after midnight, you came up to the Senate floor and we worked out an amendment when it would have been very easy for you to say, I'll see you in the morning, or have someone else handle it. And I appreciate that. I think I have every reason to believe you're going to do a fine job as Attorney General. I look forward to this questioning period when you kind of lay the groundwork. I think these confirmation hearings are important even when the odds are overwhelming. Someone's going to be proved. Thank you, Mr. Chairman.
Senator Brown.
Thank you, Mr. Chairman. Mr. Barr, I want to add my welcome to your visit here today. You have an exceptional background that I think all of us are impressed with. We're particularly impressed that someone with your options in life would choose to serve this country when you have many jobs that would pay a great deal more than this. If you're able to explain that to your wife, you should know that we deeply appreciate your sacrifice and your family's sacrifice. You're going to need all of those exceptional abilities. As I read the committee, half are going to vote for you because you'll be the president's attorney, and half are going to vote for you because you'll be the people's attorney. If you can get through that one, I think you won't have any problems with the job itself. Many have suggested that you got here without involvement in politics, primarily doing a superlative job in the responsibilities you've had, and what I've read about you primarily indicates that. But the Washington Post, I notice, has uncovered your campaigning for President Nixon. I assume that was a speech in opposition to the future President Kennedy that you delivered in elementary school. But I notice it does raise a religious issue, with the nun promising to pray for you, presumably because of her concern about your judgment in that regard. But that judgment, I think, is what this committee is going to look at. We've heard about BCCI, and I think that's an appropriate area to be addressed because it's an example of issues that will come before you, and I think it gives this committee a chance to understand how your thinking process works in looking at questions like that. The Inslaw case, I think, is another one, perhaps important for itself, but important in examining your thinking process. I believe there's going to be a focus on whether or not you'll be simply a law enforcement office or a political officer. My guess is that all members of this committee would admit your responsibilities have a little both. We're going to be looking at the kind of philosophy you bring to resolving that contradiction. But all of us, I think, appreciate the fact that someone with your background, with your exceptional ability and your integrity would choose to serve our country. We appreciate your coming before us today.
Thank you very much. Senator Cole.
Thank you, Mr. Chairman. Mr. Barr, I also welcome you. This is the third time in 3 years that you've been before this committee for confirmation. When I, as a committee member, consider a nomination for an executive branch position, I approach the process with the presumption that the individual nominated is qualified for the office. And unless events have occurred that I am not aware of, then based on your record and having chaired your last confirmation hearing, I am inclined to support your nomination to be Attorney General. Nevertheless, our oath of office obligates us to examine your fitness to serve as Attorney General. We must conclude that you possess the necessary legal qualifications, that you will relate the law to the basic values we have embraced as a nation, and that you will serve as a lawyer for the people as well as for the President. Consequently, there are some areas in which I have questions. I want to know about your general philosophy and approach as the nation's chief law enforcement officer. And I want to know your views in such areas as juvenile justice, state and local cooperation, and the competing loyalties of the Attorney General. I enjoyed meeting with you last month, and I was encouraged by what you said. The root of the crime problem, the cause and not merely a symptom, is found throughout our society. It is in the workplace, in our schools, and in our homes, not just in the criminal element. To overcome this violence, we must take a more comprehensive approach, an approach that empowers our communities, educates our youth, reestablishes a strong family structure, and keeps guns out of the hands of criminals and drug traffickers, as well as one that emphasizes crime control. Without doubt, the nation will be looking to you as Attorney General to provide leadership in this area. Mr. Barr, inside the Beltway, people frequently are more interested in what constitutes a good soundbite than what is constitutionally sound. I believe that if you are confirmed, you will find that approach unacceptable, that you will work towards real achievements and not just political wins. Our earlier talks have led me to believe that you will seek goals and solutions and not merely the political advantage of the moment. To this end, I look forward to learning more of your thoughts and views, and I wish you and your family well. Thank you, and thank you, Mr. Chairman.
Thank you very much. Then would you stand to be sworn? And then we'll, after he's been sworn. Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Would you please introduce that fine family to us, those young women who are wondering why they have to sit there all this time?
Thank you, Mr. Chairman. I'd like to introduce my wife, Christine, and my daughter, Margaret, who we call Meg, Patricia, and Mary.
Well, one thing for certain, you'll never be able to deny any of them. Welcome, ladies. As I tell most of the children of people who have to come here to go through this process, number one, it will be painless, although it will be boring. And number two, you're entitled to ask your dad and your mom for something special for having to sit through this hearing, put on your best dresses. So if you need any legal representation in that matter, promise I'd be willing to help, and will not confirm your father until he gets a commitment. You get a commitment from him as something special. Anyway, thank you very much for coming, ladies. Well, first of all, it's a pleasure to have a nominee before us in this administration that didn't graduate from Yale Law School. It's the first one in 100, I think. Not that there's anything wrong with Yale Law School, but we like to try other law schools occasionally, particularly George Washington University. But I'd like to invite you, if you have a statement, General, to make the statement, and then we'll go to questions.
Thank you, Mr. Chairman. It's a distinct privilege to appear before this committee this afternoon, and I'd like to thank you for moving so quickly on this nomination. I'm honored that the President has selected me for the position of Attorney General. It's not a position that I pursued. I never thought I would be named Attorney General or nominated to be Attorney General. In fact, I never thought I would serve as Deputy Attorney General. But the way circumstances have unfolded, I believe I am in a good position to provide leadership to the Department of Justice. As you know from my background, I am committed to public service, and I also revere the law. It is my life and my profession. And as Attorney General, I believe I can serve my fellow citizens by upholding the rule of law. The Attorney General has very special obligations, unique obligations. He holds in trust the fair and impartial administration of justice. It's the Attorney General's responsibility to enforce the law even-handedly and with integrity. The Attorney General must ensure that the administration of justice, the enforcement of the law, is above and away from politics. Nothing could be more destructive of our system of government, of the rule of law, or the Department of Justice as an institution than any toleration of political interference with the enforcement of the law. When I met with the President about this nomination, I observed that there were others who had greater stature. And he said that the most important thing, as far as he was concerned, was to have a Department of Justice that was run with professionalism and integrity. That has been his only charge to me, and I am accountable to him, I'm accountable to you, and I'm ultimately accountable to the American people for carrying out that charge. I believe that the essence of leadership is ultimately service. I've been at the Department of Justice for almost 3 years, and I have grown to love the institution and the dedicated men and women who serve in it, and I am proud to be associated with them. I want to serve the department. I believe I can serve the rule of law and the Department of Justice by protecting and fostering the professionalism and the integrity of the Department of Justice as an institution. AGs come and go, and so the character of the Department of Justice as an ongoing institution has much to do with the course and the fair administration of justice in this country. And if you confirm me, I would like, at the conclusion of my tenure, to have it said that I upheld the law and that I left the Department of Justice a more effective, stronger, and a better institution. Thank you.
Thank you very much. As you know, this BCCI matter is engulfing and touching, it seems, everything in sight, from the United States to God knows how many other countries. But although I have other questions later on, I want to begin with one to clear the air, if it's possible to clear it. I hope it is. That On November the 12th, excuse me, on, when did this air? On November 11th, last night, on NBC, correct? Yes. NBC, the following news report was broadcast. And I'm quoting, it says, the BCCI banker is Nazir Shenoy, I hope I'm pronouncing that correctly, now in federal custody in Florida facing drug money laundering charges. And Shenoy's lawyers say federal prosecutors seemed to want Shenoy's cooperation until Shenoy made a startling disclosure that BCCI had financed, was right in the middle of, covert American arms shipments to Iran. If true, that this member of the BCCI's inner circle says, what this member of the BCCI's inner circle says, means that BCCI was deeply involved in the CIA's most secret operations, playing a much greater role than the CIA has yet admitted. Then skipping 4 or 5 paragraphs, it concludes, the second to last paragraph, it says, but 2 top Justice Department sources say, under Thornburgh and his designated successor, William Barr, agents and prosecutors have been blocked or delayed again and again in going after BCCI. Would you comment on that?
The Shenoy report from last night was the first I heard about this this episode.
What do you mean by this episode?
This discussion with Shenoy. He was an original indictee. This is what my understanding of the situation is, as far as I've been able to tell. Shenoy is a BCCI official. He was one of the original indictees in the first Tampa money laundering case. We were not able to get custody of him because he was fighting extradition. We worked for 2 years to get custody of Shenoy. Meanwhile, the first Tampa case was prosecuted for the defendants that we were able to get into custody. We finally then got Shenoy in custody. We successfully extradited him. He is scheduled for trial on those original money laundering charges for January 1992. There were plea negotiations with his lawyer. I am told that in these plea negotiations, he made a proffer to agents that the agents considered to be incomplete. I don't know the full content of what this proffer was, but Shenoy and counsel were seeking a plea agreement. And one of the elements that they were asking for is something called a 5K motion, which is to depart from the sentencing guidelines based solely on the proffer without any evaluation of subsequent performance and ultimate truthful cooperation in the future. This is something that I'm told we never do. It is akin to buying a pig in a poke to let someone off on a plea bargain, cut a sweetheart deal for somebody based solely on a proffer, one that the professionals involved believed was incomplete. If we were in the business, I mean, at any one time, there are literally thousands of criminal defendants scheduled for trial on serious crimes. And if every time one of them wafts the word Iran under our nose and insists upon a sweetheart deal without any commitment of follow-through, we wouldn't be in the criminal justice business. That is my, my understanding of the Shenoy episode.
Did you learn this from the news broadcast last night?
The first that the Shenoy thing ever came onto my radar scope was last night on the NBC report. Now you have to understand, there are about 5 to 6 linear feet of documents that come into my office every day.
I'm not being critical. I just want to know when.
No, I'm just saying that, you know, it could be in some report somewhere. It could have been on a summary of events or developments that I never focused on, but the first that penetrated my consciousness was last night.
The reason I ask, and I don't doubt you for a moment, you've never been anything but truthful with me, it does, at least in my mind, raise the question of how top a priority the BCCI investigation is receiving under the Justice Department if this, unless it's not that significant an event in the minds of the Justice Department, that you as Acting Attorney General would not be aware of Chinoy's proffer.
It would not be, it would be quite unusual for either the Deputy Attorney General or the Attorney General to be monitoring plea negotiations closely, even in a case of this magnitude. And in fact, I think that if I responded to media pressure or political pressure to get the job done in BCCI and reached down and interfered with the professional judgments early on in this kind of case, I think I would be legitimately criticized. The process in the Justice Department is for these things to move up step by step, and if it requires a review or if it's escalated to my level, then I can deal with it. But I'm not going to monitor plea negotiations that are going on across the country in any case, but this maybe gives me an opportunity to talk more broadly about BCCI, which I'd be glad to do, or if you'd like to pursue.
Sure.
Okay.
If you'd feel comfortable.
BCCI, I think I'd like to look at it from a prospective and then a retrospective standpoint, really using the summertime as the pivot point. I personally did not get involved in any appreciable way in BCCI until the summer, when all the articles started appearing about alleged foot dragging by the department. And at that point,
Summer of '91.
Yes, just this past summer, and Dick Thornburgh at that point designated Bob Mueller, who was a career prosecutor, who was the head of the criminal division, to take charge and to coordinate this effort and make sure that the job gets done in the future, and also to find out what has happened in the past.
Who was in charge up to that point?
There were separate investigations going with very little coordination in various districts. Since that time, as Bob Mueller has written to
Of course, you know that's been one of the criticisms.
Sure. I'll get to the retrospective in a moment, but first, looking from the time that I've been involved forward initially, and as Bob Mueller said in his letter to Congressman Schumer, he has received since that time very clear, straightforward instructions. One, that spare no resources, whatever resources are necessary. Two, pursue the investigation as aggressively as possible and follow the evidence anywhere and everywhere it leads. Third, that there's going to be coordination and a consolidated effort. And finally, that jurisdictional turf fights are not going to be tolerated that impede this investigation. And that has been the consistent direction he has received. The investigation now is going forward in 5 different districts, U.S. attorneys' districts.
Are you now directing Mueller?
Yes. And in the District of Columbia, in addition to those 5 districts, we have a consolidated task force between the U.S. Attorney's Office here and the Criminal Division. That task force has 3 different teams. 2 are conducting investigations. 1 is providing coordinating and other kinds of support to the overall investigation. And in addition, we have the Office of International Affairs in the Criminal Division assisting all the offices with the international dimensions of this. We have right now 37 prosecutors nationwide and dozens of agents, obviously, supporting those prosecutors on this case. As far as I am aware, all allegations that have surfaced are now being pursued aggressively. And starting from the time that I've been involved, I'll accept personal responsibility for performance in this case, and I'll be held accountable for it. And Mr. Chairman, if you want to hold hearings in several months or whatever time frame to determine what progress has been made, I'd welcome that. But I will take personal responsibility for the performance of the Justice Department on this investigation. But I want to make something clear, and that is that this is a complex case. We have a standard at the Department of Justice, an indictment standard. We feel we need to have evidence sufficient to support an indictment in hand, that we can prove our case in court. And a lot has been said about not wanting to have a political Justice Department. And I agree with that. And there's a lot of different ways politics can come into play in a case. It can be, on the one hand, and I think many of you are thinking of this, you shouldn't sweep anything under the rug. Don't cut anyone a special break. Don't show favoritism. Don't withhold an indictment that should be laid down because of political influence. But there's another side to the coin, and that is, don't hand down an indictment because of political pressure. Don't lower the standard of indictment just because it's politically convenient. That standard, if I become Attorney General, is going to be one standard, and it's not going to be changed for anybody in this country. And I don't care how much political pressure is brought to bear. I don't care what the op-eds say. I don't care what the journalists say if it's not fast enough for them. And I don't care what the political pressures are. That standard is staying where it is. And right now, the career prosecutors in the department, and believe me, I've been pressing them, have explained to me very coherently what evidence is lacking that prevents us from laying down an indictment today. And I've insisted on explanations, and I've gotten them, and they're coherent, and I think they're right, and they're coming from the career professional prosecutors. And nothing, from a personal standpoint, it'd be great if I could just throw an indictment on the table and say, see, guys. But I'm not going to do that. Until that standard is met, there's not going to be an indictment in the BCCI case. As it's met, there will be indictments. So that's talking prospectively. And let me just say, we have to support the indictments with evidence. And that means people and documents. And most of this activity occurred overseas, and it was carefully carried out to avoid regulatory scrutiny. Much of this activity was conducted in countries where there are bank secrecy laws. It's very difficult for us to get access to the records and people we need, but we're working to do that. I'm not going to take the Price Waterhouse report, staple an indictment to it, and throw it into the bin. We're going to get the evidence before any indictment comes down. Now, looking retrospectively, I've asked that a thorough review of pre-July activity be conducted.
Before you do that, I apologize for interrupting. There'll be two other things that'll be raised, and I just want to raise them now so you can throw them in the bin. It is my understanding, and I do not know this for a fact, that your former law firm, Shaw and Pittman, now represent the president of BCCI. Is that true, to the best of your knowledge?
I learned yesterday that they're representing NACV.
And what is his position?
I think he is one of the very senior people.
Now, was there any work done by that law firm when you were with the law firm as a partner or as an associate
in
regard to BCCI?
Let me make it clear. This is my understanding. The law firm, I am told, represented people who owned Financial General back in '78 when it was being purchased by others, one of whom was Frank Saul. And apparently it says in the paper that Frank Saul suggested that this was a move by BCCI to take control. That was the first year I was at the firm. I was an associate. I don't believe I had any contact with that matter. That was, as I say, the people representing a person who was a shareholder and whose interest was ultimately bought out. My understanding is that NACV became a client of the firm well after I left, and I've been gone for almost 3 years.
Well after you left as a partner?
Yes.
Let me make
I
sure
left the.
You were there as an associate in the early 70s?
Correct. Then I'll give you the chronology. I was at the law firm from 78 to 82 as an associate. I then returned to the firm from the White House and was there from 83 to 84 as an associate, made partner, and was at the firm as a partner from 85 to 89 when I came into the administration as the head of OLC. So I've been away from the firm for almost 3 years.
So when you say you left the firm, when your last statement you say when you left the firm, you're referring to
89.
1989,
yeah.
When you left as a partner?
Yes. Okay. My understanding is NOCV has become a recent client of one of the partners there.
So the best of
I have let me just say, I have no financial interest in the firm. I liquidated that completely when I left in 89. I have no arrangements with the firm.
But when you were at the firm as a partner, not as an associate, the period when you were a partner, 85 to 89, where you would, I assume, have more access to information relative to what the firm was doing than when you were an associate. Can you tell us whether or not the firm, at the time you were there as a partner from 85 to 89, in that time frame, whether or not they were representing BCCI or any of the principals in BCCI?
Not to my knowledge.
Not to your knowledge. That's good enough for me. Now, I'll come back with some other questions. My time's up.
Let me just say on that the firm has some international bank clients. I was never involved in that practice, and I never became aware of them representing BCCI.
For the record, how big is the firm?
Right now, it's 240 or 50 lawyers.
240, and how many partners, roughly?
Probably around 70 or 80.
Now, if you'd like to, I'm not asking you to, you want to finish your answer with regard to BCCI, not prospectively, but as you started, or if you want to wait till later, it's up to you, because otherwise I'll yield to my colleague, Senator Thurman. I don't want to cut you off. I just wanted to get that in so it didn't linger.
Okay, maybe we can, I was going to give an overview of what's happened in the past and largely defend the department's record, but I'll hold off on that until someone else raises the BCCI issue.
I think it would be helpful, as long as you're having this, to get that retrospective look right now.
Okay, I've asked for a retrospective look. I think it's important that if there were mistakes made, that we can learn from our mistakes and make sure these kinds of slip-ups don't happen again. So that's one reason. And the other reason is because there's sort of lurking in the background here some suggestion that somehow there's some wrongdoing or mischief involved. And to the extent there are any allegations like that, I want those all pursued and run to ground. But based, and let me also say that I am frankly not immersing myself in all the details of what happened prior to July. I will have people working on that. I learn a little as it goes on, but my priority is what happens from now on in and making sure the job is done. But from what I do know, I think that much of the, I think the record is fairly good, and I think much of the criticism is unfair. The major criticism is that the department didn't act quickly enough. There are basically 4 categories of offenses that BCCI is alleged to have committed that touch upon the United States. First is money laundering. Second is regulatory offenses, the secret acquisition of financial institutions in the United States. The third is a wide-scale fraud, a Ponzi scheme where a depositor's money was taken worldwide. And the fourth is general allegations about public corruption, that there's somehow a pad somewhere and bribes being paid to public officials. Starting with money laundering, most of the money laundering allegations centered on Florida, which was the major area of drug activity and money laundering. And the Department of Justice has prosecuted a major money laundering case against BCCI, the only one so far brought to fruition. It was a Customs Department undercover investigation. It was a complex investigation, and ultimately we were able to prosecute 5, I think, of the BCCI officials, but also then had a plea agreement with the bank where we got the largest payout forfeiture in history of financial institutions. And then there's been a second phase of this, a follow-up in Tampa, where in September '91 we've brought a follow-on indictment against other individuals. The money laundering, by and large, the big picture is that the money laundering allegations were detected and have been prosecuted. Now, there is an allegation in the Washington Post, I believe it's the Washington Post editorial page today, that there were 125 DEA cases in DEA's, relating to BCCI and DEA's files, and that somehow we didn't get the picture and didn't focus on these 125 cases. I am informed that the 125 figure is the number of current reports in the DEA files, most of which relate to the investigation and the activity that was carried on from '86 through '90 in that money laundering case. The second area of allegations are regulatory offenses. And as I said, that is the notion that there was secret acquisition of financial institutions. The basic allegation there is that the law enforcement people, both Justice and Treasury, because there were 2 Treasury agencies involved, Customs and IRS, that while they were covering the money laundering part of the case, they acquired some evidence about the alleged secret acquisition of First American, and that they never passed that on, or that somehow that slowed down the investigation. I think, again, I'm talking here the big picture in my preliminary assessment, because I haven't immersed myself in all the facts, but the general pattern, it seems to me, was that this evidence was passed along to the Fed, maybe not as promptly and tidily as it should have been, but basically the information was transmitted to the Fed after the takedown of the undercover operation. The evidence that was transmitted to the Fed, which had primary jurisdiction here, these were regulatory violations, and the Fed in the first instance is the regulatory agency that should be investigating, that they were of limited utility to the Fed because they were sort of general nature, hearsay, gossip, and that the Fed was really focusing on trying to get more tangible evidence. And my understanding of the Fed's position is that it was the Price Waterhouse study that came out in December of 1990 that was the big breakthrough for the Fed. And remember, the Fed has a lower standard of proof. They're operating in a civil environment, not a criminal environment. So it was in December '90 that the big piece of evidence, as far as the Fed was concerned, on the regulatory offenses came out of the UK. And my general sense is that the hearsay and the gossip and the rumor and the general corporate knowledge kind of evidence that was transmitted to the Fed from the money laundering investigations, I think it's sheer speculation and quite unlikely that that would have materially advanced the Fed's ultimate investigation. In any event, the Fed did refer the regulatory case to us in January of this year. So we have had, the process has worked. The Fed, as the regulatory agency, has made a criminal referral that came to the Department in January '91, and the Department is pursuing those regulatory offenses, potential offenses. But as I say, the issue for us is getting the evidence from overseas. I think that the allegations of the Ponzi scheme, the worldwide fraud, likewise arose after the Price Waterhouse report, and the allegations of corruption are of relatively recent vintage and of quite a general nature, and those are now being pursued. And these issues arose in 1991. I've already discussed the fact that it's very hard for us, tedious process, to gain the evidence that we need as a predicate for an indictment. And I think it's unfair generally to be conducting an autopsy on a live body. This is an investigation in midstream. And ordinarily, the Department of Justice is not and should not be driven by a political timetable. I don't know why the people feel we should be handing down indictments immediately here. We will hand down indictments when the evidence is there to support it. There's a saying, I think all of us know it, that the wheels of justice grind slow but exceedingly fine. And most people appreciate that, because we have to go through a process. And the reason we are ultimately able to do justice and get that fine grinding at the end where all the allegations are handled in a coherent way is because we go through a process. No one at the CIA, the State Department, or the White House, or anybody outside the Department of Justice, as far as I am aware, has ever attempted to influence the course of this case. And no political influence whatsoever has been brought to bear on this investigation.
Have you been asked to update the White House on the state of the investigation of BCCI?
When?
Since you've taken over primary responsibility for it.
There were two instances where there are only two communications I'm aware of with the White House on the BCCI case. On the investigation, one was a lunch I was having with Boyd and Gray where we were going and discussing that the department was would be having a transition at that point. And I said that the BCCI matter was, you know, an important priority area, and he asked me to explain all the adverse press that the department had been getting over the summer. And the only other instance I'm aware of is where we, basically following up on that, went to brief the counsel's office. I didn't do it, someone else did, on the allegations that have been made in the progress of the investigation. But no one in the White House has ever attempted to influence this in any way.
Thank you. Senator Thurman.
Thank you, Mr. Chairman. Mr. Barr, when a person goes into a new position, they generally set up goals. What are your goals during your tenure as Attorney General?
I think talking about specific goals and priorities, and I think I've said this to a number of you on courtesy calls, is a little bit misleading in the Department of Justice, because we're called upon to administer the law.
Have you been asked to update the White House on the state of the investigation of BCCI?
When?
Since you've taken over primary responsibility for it.
There were two instances where there are only two communications I'm aware of with the White House on the BCCI case. On the investigation, one was a lunch I was having with Boyd and Gray where we were going over a number of issues that were going to be coming up in the fall, and discussing that the department was would be having a transition at that point. And I said that the BCCI matter was, you know, an important priority area, and he asked me to explain all the adverse press that the department had been getting over the summer. And the only other instance I'm aware of is where we, basically following up on that, went to brief the counsel's office. I didn't do it, someone else did, on the allegations that have been made in the progress of the investigation. But no one in the White House has ever attempted to influence this in any way.
Thank you. Senator Thurman.
Thank you, Mr. Chairman. Mr. Barr, when a person goes into a new position, they generally set up goals. What are your goals during your tenure as Attorney General?
I think talking about specific goals and priorities, and I think I've said this to a number of you on courtesy calls, is a little bit misleading in the Department of Justice, because we're called upon to administer the law across the board and make sure that all programs and all areas of enforcement are covered. And it's, as Senator Kennedy said, it's a very difficult job to do in a period of scarce resources. And in a way, I hate to suggest that by giving emphasis on one program that we may be giving short shrift to another. I don't mean to suggest that. And so one of my priorities is to try the best I can to cover the whole waterfront, so that at the end of my tenure, it cannot be said of me that I let the ball drop in a particular area. And that's an important priority, I think, for any Attorney General to have. It doesn't necessarily get headlines, but that's the business of the Department of Justice. The second priority is also sort of a cross-cutting nature, and that is, before getting into specific areas of emphasis, and that is something I said in my opening statement, which is to try to foster and build upon the professionalism and the integrity of the institution itself, so that when I leave, people will say that it's a better institution, it's a more professional institution. And I think that the way I can do that as Attorney General is both by personal example, by being professional in my decisions and my dealings, but also to insist upon it from top to bottom in the work that's done in the department. Beyond that, there are several areas of emphasis. Obviously, drugs has to continue as a top priority. In my view, it is a long-term struggle. We're talking here about the Cold War. We're not talking about Desert Storm. This problem took decades to come about. It's going to take decades to cure. But part of my responsibility and my priority will be to keep the pressure on so we continue to make progress. Beyond that, I want to give increasing emphasis to the problem of violent crime. Violent crime is intolerable in the United States. And while it is largely a local concern, 95% of it or more is really a state and local jurisdiction, and should be, I do think there's some areas where the federal government can provide greater support and make a real difference in the violent crime problem. And later on, I'll be glad to discuss the details of what I'm talking about. Next, I would say that civil rights would be one of my areas of emphasis. I think there's broad area of agreement. Sometimes we focus on areas of policy disagreement, but there's even a broader area of agreement in the civil rights area, and that is that discrimination is abhorrent and strikes at the very nature and fiber of what this country stands for. I believe that there is still, although progress has been made in this country, that there is still discrimination in this country, and enforcing the civil rights laws would be a high priority of mine. I intend to be vigilant in watching for discrimination, and I intend to be aggressive in rooting it out and enforcing the laws against it wherever it's detected. The first experience I had as acting Attorney General with this was in the area of fair housing that Senator Hatch alluded to. Shortly after I took the position of acting Attorney General, I saw that there were a report came out of HUD about discrimination in housing, and followed by a report from the Fed concerning discrimination in mortgages. And I recognize there's been a lot of talk about how that data has to be massaged and sifted and studied and analyzed. But in the meantime, I told John Dunn that that didn't mean we should sit on our haunches. And I asked him to put together a stepped-up enforcement program And he talked about Senator Hatch's bill to start using testers. And I thought that was a good idea, but I found or concluded that we didn't really need new legislation. We could do it, and I asked that we reprogram money into the program, over $1.4 million over 2 years, and that we embark on a testers program. This would be the first time the Department of Justice has used testers directly. We've relied on the evidence before, but now they'll be working for us directly. And also I asked John to set up a group of regulatory agencies that are involved in the mortgage area so that we can have a coordinated enforcement program. I believe that group is meeting and setting out an enforcement program in the mortgage area. So I intend to be proactive, and as I said, civil rights will be a priority. And finally, I would say white-collar crime. And there the challenge is to keep up the momentum in the areas where we have been making progress. I think we've been making a lot of progress on financial institution fraud, in large part because of the infusion of resources we got in the Crime Control Act of 1990. And we've been making progress in government contracting, and in HUD fraud, and in affirmative civil litigation. But the other part of the white-collar challenge is to anticipate these slumbering giants before they become problems like the S&L problem, and try to get ahead of the power curve, get the resources in place, and get the program in place. And I've been chairing the Economic Crime Council, where we have designated areas of insurance fraud, pension fraud, computer crime, and healthcare fraud as new areas of emphasis, and starting to put in place a program to deal with them. But as Senator Kennedy said, I have these, while these are priorities, and while I will be trying to give them emphasis, we are in an area of very scarce, an era of scarce resources. The President has asked for a 60% increase in the budget over 3 years. His past increase for the 92 fiscal year was 15%. I have to say the Senate, in their appropriations, basically gave the President what he wanted on the Justice Department, but unfortunately in conference committee we lost $472 million. That is a tremendous blow to the department, and means a lot of the initiatives we were hoping to carry out cannot be carried out. So another cross-cutting priority of the Department of any Attorney General, and it's becoming increasingly a role that the Attorney General has to play, is as a manager, to make sure that we are effectively investing the money and the resources. And so, Senator, those are my goals as Attorney General.
What about filling these judgeship vacancies? About 2 weeks ago, I had it checked up, and we had 125 vacancies. It seems to me it's taking too long. And is that the White House, or is that the Justice Department?
Well, it is a long process, Senator. I think we had a total of 150 vacancies, and my figures show that we have 41 nominations pending. We have tentatively selected 66 candidates who are now undergoing either FBI background checks or ABA reviews, and we're in the process of interviewing for 18 additional judgeships, and that we have not received recommendations on 25. Now, I agree that it's a slow process, but it's an important one. We did have a big backlog and because of this creation of the new judgeships, and it's a long process because we have to make sure that we're putting people who have the proper character and integrity and competence on the bench, and that requires the FBI background, it requires the ABA screening process, and that takes a lot of time. But I think the big picture that we have 41 nominations pending and 66 already in the pipeline, with only 18 interviewing and 25 no action on yet, isn't that bad a position to be in. But I agree with you. We have to do better, and it may require putting more FBI resources into it.
Would it be possible to employ more FBI agents to get this thing done? I'm getting complaints all the time about filling these vacancies. The judges are complaining, and they say they're overworked, they can't get the job done. We created the vacancies, and now they're not being filled. Can't you employ about 50 extra FBI agents and get this work done?
I don't know if I can employ them, but obviously we can shift FBI agents from other areas to do the backgrounds. But this is a pipeline we're talking about. It has a number of different points along the line, and even if we were to push through these 66 who are going through the process now, either background or ABA, this committee also has limitations on its capacity to process these people quickly. I'm not suggesting there's been delay at all. I'm just saying that right now there are 41 pending. We are just about...
Where's Senator Biden? I want him to hear that.
We have 66 more coming down the pike. I think this
It's taken 2 or 3 months for the FBI to investigate. It's taken several months for the ABA to investigate. I think that's ridiculous, to be frank with you.
Well, I think we have to expedite those investigations and get more nominations up to the committee. But the committee also has to investigate
these positions ought to be filled. Now, if it's the Justice Department's fault or the White House, they ought to correct it. If it's the fault of this committee, it ought to be corrected. Well, these positions ought to be filled. Now, I'm sure you realize the importance of a good working relationship with the Congress. So how would you hope to accomplish that?
I think that I've been able to establish a good working relationship with the Congress, both on the Senate side and the House side. I've been willing to work closely with committees and with individual members to accomplish legislative objectives. I played a role in getting the Debt Collection Act through, and as Senator Simon mentioned, came up and spent an all-nighter here on the Crime Control Act. I worked closely with Senator Biden on this year's crime bill, which passed the Senate. And I think the key to it is mutual respect and open communication.
Now, do you feel there's sufficient resources at both the state and federal levels to effectively fight organized and white-collar crime? And would you hesitate to ask for more funds if you need them?
Well, as Dick Thornburgh said, we could always use more resources in law enforcement. We only spend a little over 1% of our budget on law enforcement in this country, and on the federal level, and about, I think, 3% on the state level. And my impression is that any law enforcement officer in the country, state or federal, can always use more. So it's a question of prioritizing and doing the best you can with limited resources. On the organized crime front, I think we have a good program in place. We have recently changed our strategy, as you know, whereas before we were focusing exclusively on the La Cosa Nostra and certain other organized crime entities. We've now expanded the definition of organized crime so that we could go after other groups, emerging groups and non-traditional organized crime groups, and we are deploying those resources now. On the state level, that's really a matter for the state and local authorities to determine how much is enough resources. I myself would not like to see a scaling back of what is being invested in law enforcement on the local and state level.
The Office of Professional Responsibility has made fine contributions. I presume you expect to continue to provide support for that office.
Yes, I do support the Office of Professional Responsibility. As you know, we have a new IG that was created, and there has been some issue as to the respective jurisdiction of the IG and the Office of Professional Responsibility. On the one hand, I think part of the statute suggests that the Attorney, or maybe it's the legislative history, that the Attorney General may consider subsuming in the IG's office OPR, merging the two. On the other hand, I believe there is also language either in the statute or legislative history suggesting that another consideration might be given to shifting investigative slots from the IG to OPR, basically creating a larger, far bigger organization of OPR, while at the same time having the IG. And those offices have given me their views on the allocation of responsibility. And I decided when I became deputy to basically get a year of experience or a year or more of experience under our belt with these two offices in operation. before making any decisions, because I wanted to see where the pressure points were and how the relationships were and what roles they were playing. And while I haven't come to a final conclusion about all the details, I think that we should continue to have OPR as a separate entity, enforcing particularly the professional responsibility of the lawyers in the department, and assisting the Attorney General in ensuring the highest standards in the department.
I believe my time's up. Thank you very much.
Thank you, sir.
Thank you, Chairman. I want to say that it's difficult to differ with your orders of priorities. I think the order that you've represent them pretty much certainly express my own kind of priorities in the Justice Department, and I think you pointed out whether you're going to be able, and the new initiatives I think you ought to be commended for. And the fact of the matter is there's been more action over in HUD than there has in the Justice Department in recent times in the areas of enforcement of civil rights. And as I understand, even though it's in a preliminary stage, what you're attempting to do there, I think, is noteworthy and commendable. Let me go into some other areas that have not been touched. One of them has been mentioned, but I'd like to, if I could, direct your attention to the Brady waiting period for handguns. The Brady handgun waiting period is an important proposal your predecessors supported on the condition that it be included as part of a comprehensive crime package, including habeas corpus, death penalty, and other reforms. Well, the proliferation of assault weapons, though, continues to be a problem for law enforcement and every law-abiding citizen, and the success of waiting periods and background checks at the state level is compelling. They provide a cooling-off period, and the only opportunity to determine whether a prospective firearm purchaser is not entitled to make that purchase because of a criminal record or history of mental illness or other disqualifying factor. Now, the Brady waiting period the administration is willing to accept as part of the crime package applies only to handguns. The assault weapons, obviously, are at least as lethal. And why shouldn't we expand the scope of the Brady bill to encompass assault weapons as well?
On the assault weapon front, the proposal before us is the DeConcini amendment, and I think, I don't know if this is a new statement or not, but I would support both the Brady bill waiting period and the DeConcini amendment, provided they were parts of a broader and more comprehensive crime bill that included tough enforcement provisions, including very tough provisions on the use of firearms in crimes and illegal purchase and trading in firearms, which are part of the package that passed the Senate. Now, to be candid, on the waiting period,
I would prefer an approach that was directed toward point of sale. And I know that we're not at that point yet technologically. It's going to require more investment, and I've been involved in infusing those resources there to upgrade the records. But the important thing, I think, ultimately will be a system that's based on state records, a state system. So I think the House approach is preferable, frankly, to the Senate approach. On the DeConcini amendment, I would prefer a limitation on the clip size, but ultimately I would recommend the President sign a bill that had the Brady waiting period and the DeConcini assault weapons provisions in it, as long as we had other tough crime measures in it that dealt with the other problems. I have not considered before whether the waiting period should apply to assault weapons, but and want to think about that. But off the top of my head, I don't think there should be an objection to that.
Well, I think that's, as you know, the DeConcini on the assault weapons does not provide for the waiting period for the assault weapons.
And although it includes a number, I believe it's 11 sets of assault weapons, there are clearly others that have been that result in the same kind of destruction and havoc and threat to law enforcement personnel. I think the fact that you're forthcoming in terms of the waiting period for assault weapons is very constructive. We have
And unusual for an Attorney General nominee.
We have here just the application for the purchase of weapons. And as you're familiar, prior to 1968, they didn't even ask the 6 or 7 questions, which are the most rudimentary questions that there are. And of course, without having the opportunity to give local law enforcement the opportunity to check those, the significance and importance of them are significantly compromised. And it's been to try and give that period of time to local enforcement that the waiting period has been supported, and there have been some important successes in New Jersey. Over a period of time, some 10,000 convicted felons trying to buy guns have been identified, and I'm not going to take the time of the committee to go through those. But the fact that you would be willing to consider, it seems to me to be logical, if it's important in terms of dealing with violence on the handguns than on the kinds of weapons that have been used that have brought such destruction and violence to our fellow citizens, would certainly be justified as well, and that are threatening many of those in the law enforcement community. So just let me ask you on one other related area, and that is on the reviewing the licensing requirements for the sale of assault weapons. As you probably know, and I won't go through in great detail, but it's virtually 4 or 5 of the same kinds of questions, and you can get a license to sell these assault weapons and sell them to virtually anyone. And it seems to me that if it's good enough in terms of the purchase of the handguns, in terms of checking out the background, and good enough in terms of trying to deal with assault weapons, having some kind of idea about who's going to be selling these, who's going to be the licensee, given some of the recent information about who is selling assault weapons is worthwhile as well. Would you be at least willing to visit and talk about that particular issue and see what suggestions you might have on that?
Sure, Senator. I'm always willing to consider that. In considering restrictions on the lawful sale of guns, I do start out with the threshold considerations that the most effective way ultimately of dealing with violent crime is to deal with violent criminals, and that anything that focuses exclusively on lawful sale is somewhat of a feckless exercise. But as part of a comprehensive approach, I think it's legitimate to take a look at reasonable steps, recognizing that there is a tradition of private gun ownership in this country and a legitimate interest in that, but nevertheless looking at reasonable steps as part of a broader approach to controlling
the deadly use of firearms that is becoming an increasing part of the plague of violence, the crime that we have in our streets.
I liked your earlier answer better, but I'm glad to hear this one too. And I'd say to my good friend from South Carolina, if you need any recommendations on those vacancies up in Massachusetts to fill those, I'd be glad to have them. Let me go to another area, and that's the area that we talked about at the time that we had our visit, which I very much appreciated, and that is with regard to the Wichita Operation Rescue case, and the decision to file a brief in the Wichita Operation Rescue case, the Women's Health Care Services versus Operation Rescue. As we understand, historically, the federal government has protected the individual rights, and when protesters attempted to prevent the black Americans from attending newly integrated schools by blocking the students' access, the federal government stepped in to ensure the students' safe entry. And that was done at a time when there were many that were really, out of sincere belief, believed that the law was wrong during that time. There wasn't really a question whether they believed it was right or wrong. Still, the Justice Department acted. But in this case, the United States Justice Department reached out the district court in Kansas and entered the dispute on the side of the lawbreakers. It weighed in with those who would forcibly deny a woman federal constitutional right to abortion. And it as far as I'm concerned, poured gasoline on an already volatile situation by making it appear that the government supported the clearly unlawful acts of Operation Rescue. The government had already stated its position in a brief before the Supreme Court. Defended in both cases the same entity, Operation Rescue, was even represented by the same attorney, so there's no reason to believe the judge in Kansas would not be appraised of the pending Supreme Court case. Why did the government feel it necessary to sort of fan the flames in Wichita and to argue that Operation Rescue should be freed from the court's order prohibiting its illegal activities?
Well, thank you, Senator. This gives me the opportunity to describe what happened, because I think it has been mischaracterized largely, and people drew the wrong conclusions from the way it was publicly presented. And in describing it, I'd like to emphasize 3 points. First, this was not viewed as an abortion issue in the department. It was viewed as a issue of jurisdiction and the reach of the so-called Ku Klux Klan Act of 1871. Second is that the department did not side with the demonstrators. On the contrary, we condemn those who break the law and who violate other people's legal rights. And third, that this was not a gratuitous action by the department where we reached out and tried to stir up an issue. On the contrary, we felt that circumstances came about that really drew us into it, and we tried in good faith to deal with it in a lawful way as we understood it. The first point that I think bears emphasis is that Operation Rescue demonstrators who block abortion clinics are lawbreakers. They are treading on other people's legal rights. I do not support or endorse or sympathize with those tactics. As the President said, everybody has an obligation to obey the law, and as a government official, my responsibility is to enforce the law and to protect people's rights. The issue in Wichita was not whether those demonstrators should be dealt with. The issue in Wichita was which statute should be used to deal with them, which law enforcement agency should be used, and what court system should be used to deal with the demonstrators. And we believe that the applicable statutes were local, and that the local police should be the law enforcement agency, and that the local courts could deal with it. And this has been, in fact, in city after city around the country, that is how it has been handled locally. In Wichita, there was an attempt to federalize the issue. The clinics went to federal court claiming that there was a violation of the Ku Klux Klan Act and seeking the intervention of federal marshals to enforce their rights of access. Now, before Wichita, I learned at the time, I hadn't really focused on it before until the Wichita matter came up to me. But before Wichita, as you mentioned, this same effort had been made to federalize this issue, and that was in the Washington, D.C. area. And that had been litigated up to the Supreme Court, and 3 to 4 months before Wichita, the department had filed a brief in the Bray case in the Supreme Court saying that the Ku Klux Klan Act did not give federal jurisdiction in these kinds of matters, that it required a class-based animus, certainly racial and possibly sexual class-based animus, but that was the limit of the jurisdiction under the Ku Klux Klan Act. So that was a position we had already taken by the time Wichita arose. We had the additional situation where the district court judge in Wichita bought into the Ku Klux Klan Act theory. He issued a very broad injunction, sweeping injunction that had very stiff, as a condition of demonstrating, imposed I forgot what the term is now. But anyway, the demonstrators had to pay in substantial monies as a condition of demonstrating. That concerned us. And then the order itself, the injunction itself, had very detailed instructions to the marshals about how to enforce the order. The judge started holding press conferences and made statements, at least they reported to me, about filling the jails, statements hostile to the elected officials, and also indicating that the Department of Justice fully supported his position. A number of components expressed concern about this state of affairs, and we had wide consultations within the department, and it was decided that the best way to proceed, where we had already taken the position that the marshals did not have the jurisdiction to go in and do the things that they were now being told to do by the district court judge was have the marshals obey the judge.
Have them obey the law. And call on everyone to obey the law. And then file an amicus with the court where we submitted the Bray brief, not re-arguing the matter, just giving the judge a copy of the Bray brief to make it clear what our legal position was, but at the same time telling everyone to follow the judge's order. And I think for a period of time it helped diffuse the situation out there and focus the attention on the courts and the legal process where it should be, rather than on the streets. But several days after that action, it appeared to me that other elements in Operation Rescue rekindled it and violated the law. They were arrested by, most of the arrests were by local police, but the marshals made the arrests, and I believe a number of them are being prosecuted for interfering with U.S. Marshals. But it was a legal position about the jurisdiction under the Ku Klux Klan Act, as I said, and we felt it was the proper thing to do given the earlier position we had taken.
I wonder if I could just finish. Sure. This is a very helpful statement and good one. There's just a final couple of points on this, if I could inquire, Mr. Chairman. Do I understand you're saying that you think the federal court should not have jurisdiction to prevent interference with a woman exercising her constitutional right to choose abortion?
No, I was saying that the Ku Klux Klan Act doesn't provide that jurisdiction. I wasn't taking a policy position.
Well, you're aware that 3 federal courts of appeals have decided this issue, the 2nd, 3rd, and 4th circuits, as well as at least 12 federal district courts have held that Section 1985-3 can be used to prevent groups like Operation Rescue from blockading clinics. And the rulings have been based on interference with the right to travel. Only 3 district courts, no courts of appeals, have taken the views espoused by the Justice Department, which would deny women seeking abortions the protection from these law breakers. I mean, effectively, you're saying, on the one hand, they have a constitutional right, but you're leaving it up to the local law enforcement. And even in this case, you advocated that they lift the injunction against those that had been interfering with the clinic. And even in the face of the attorney that said, even if they don't lift it, I can't be, I'm not going to urge that they not continue their interference and their activities. And we're trying to find out what really the distinction is between a Justice Department that was prepared to go the extra mile on the basis of race over a period of 30 years to guarantee a constitutional right, and not prepared, evidently, to go to give the assurance of the protection and the safety to an individual here that is trying to pursue a constitutional right.
I think the issue for us as a matter of law was whether the Ku Klux Klan Act of 1871 was intended to provide that basis. I wasn't taking a position on whether the government should or should not do that. Let me give you an example, and I don't mean to equate the two or analogize here, but I went to Columbia University during the riots in the late 60s. People interfered, private citizens interfered with my constitutional rights. And I'm not saying this is an analogous situation completely. But when people blocked me from getting into the library, I know how it feels to be blocked when you're going about your lawful rights, and it's quite offensive. But even though I was being blocked in the exercise of my constitutional rights, I was being blocked not by the state, but by private people. And my remedy there was to go to state courts and get the state police, the city police, to get them out of my way, which is what ultimately happened. Now, with the Ku Klux Klan Act, the federal government has been given a role to play in certain circumstances where private parties combine to interfere with constitutional rights. But that's an exception to the rule. And the issue was whether that statute, passed in 1871, was designed to give the federal government that kind of role in the matter of abortion. And it was the position, when this issue came to me, the department had already taken a position on the issue.
Well, I'll just cease and then hope you give responses. I understand the 1985 prohibits the conspiracy to deprive person, the classes of persons from equal protection or equal privileges. Operation Rescue blockades are aimed at preventing pregnant women at obtaining abortions. Now, Congress said in the Pregnancy Discrimination Act, and that passed 75-11, that discrimination based on pregnancies is sex discrimination under Title VII. So the Justice Department action in Wichita abandons it's a traditional role of advocating the protections of the civil rights under Title VII. If we've said that it is under Title VII with the Pregnancy Discrimination Act, falls within that, it would appear to me that there are those kinds of requirements for the protection of individuals. I don't know whether you have any kind of comment. My time is gone.
I'd want to have, I'd want to see that issue briefed before reaching a conclusion. But off the top of my head, my feeling there is that if the class that's being invidiously discriminated against are pregnant women, that's not what was happening here. These people were not invidiously discriminating or demonstrating against all pregnant women. They were against abortion, both the patients and the people performing the abortion. That was the activity they were demonstrating against. But I'd want to have that issue fully briefed before I reached any conclusions on it.
Thank you, Mr. Chairman.
Let me ask the nominee as well as the committee scheduling issue here. We are, this was noticed for continuing tomorrow as well. I have no intention of ending now. We're going to go for a while longer. But it is my inclination, but I'd be interested in my colleague input, that we finish today about 5:30. And that would get us so that we have at least two more of our colleagues, maybe three, or excuse me, 3 to 4 more of our colleagues be able to ask questions, and then begin tomorrow at 10 o'clock. Things are going fairly smoothly. I think we can just keep going along at that pace, if that's all right with the committee. Is that appropriate? All right. Well, then why don't we give you a chance to stretch your legs, a 5-minute break right now, and then we'll and then we'll continue. And
I always say, you got it. How do I get it?
going to pull that light out again.
Write down Mark's number, because
Just shut that.
yes. Okay. Well, if you guys need a ride, if you need a ride,
No, I have.
oh, you do.
Hearing will come to order. Senator Grassley, and before you begin, Senator, I'm told that there is going to be a vote around 5:15, and so hopefully we can get 3 or 4 more of our colleagues in before we break for that vote, if that's possible.
I haven't been following, but what has been our time allotment? I forget.
Technically, it's been 15 minutes. In almost every case, it's gone longer.
Okay, well, I probably won't use more than 15 minutes. Mr. Barr, as you probably remember, and I'm sure that we've talked privately and other times that you've been around my office, of my interests in the False Claims Act of 1986. I was involved with the writing of that act, and as everybody knows, that act was passed to give incentive for individuals who know about fraudulent use of taxpayers' money, the ability to take cases to the court and get a judgment or get a portion of what the Treasury would find in a favorable judgment. For the False Claims Act to work, it's very important that the Justice Department not fight efforts by private qui tam relators to pursue claims on behalf of the Treasury. Sometimes I've had cause for concern whether or not there's been a real commitment on the part of DOJ to prosecuting qui tam suits. My question to you is not accusatory or anything, but could I count on you to ensure Justice Department's cooperation with qui tam relators and to continue what I thought was Dick Thornburgh's commitment to the Department prosecuting government fraud?
Well, absolutely. We're strongly committed to prosecuting fraud against the government. On the qui tam provisions, we are, as you know, your statute has spawned substantial qui tam practice. I think there have been 370 cases filed since that act. We've entered 59 of them. And qui tam has, you can't quarrel with success. It has been successful in leading to substantial recoveries for the United States. I believe we've recovered so far about $134 million. We're monitoring the qui tam regime carefully, and as far as I'm aware, there are basically 2 areas of concern. I know you're familiar with our concern over government employees using information that they've gotten while government employees and then going out and bringing a qui tam action so that they get part of the take. And I think we're working with you on seeing how we can fine-tune the statute to address that issue. And I'd like to continue to work on that effort. The second area of concern is the extent to which a qui tam case over which we don't have any control or limited control might work at cross purposes with a criminal investigation. And those are some of the areas where there's sometimes some tension, where we're pursuing a criminal investigation first, because if this was completely a Justice Department show, we go criminal first, civil second. And sometimes if there's a qui tam suit out there, it's a little hard to coordinate with our criminal, which we always give first priority. But so we're sort of amassing experience as this statute works its way out and as case law develops, and to the extent we see problem areas, we'll be back asking for some changes, and we know of your interest in it, and would obviously come to talk to you first about any problem areas we saw. But we're committed to prosecuting government fraud against the government, and maintaining the integrity of our procurement programs.
Yes. Well, I believe that there are some areas of, that it's worth our visiting and talking in detail at your staff and my staff's level. I will have some things that I can suggest. I'm not so sure that we will be able to work out some compromise, but I'm surely very happy to sit down and talk about that and to suggest what some of those are. I previously mentioned Vice President Quayle's civil justice reform proposal. I'd like to discuss some of these proposals and get your views. One of the reforms that I'm most sympathetic with concerns alternative dispute resolution. Again, I got some legislation passed in this area last fall, signed by the President, now law. When you were before the committee to be confirmed for Deputy Attorney General, I solicited your opinion on ADR and arbitration. In written responses, you expressed your strong sympathy with efforts to encourage arbitration, but declined to give an opinion on the constitutionality of delegating judicial decision-making authority to private parties. So now that you're back here again, I'm curious to know if your opinions in this area have grown in the past 2 years. Do you remain sympathetic to arbitration and ADR efforts? Do you see any constitutional problems with the use of arbitration as a substitute for judicial decision-making?
First, as to the ADR as it was embodied in your act in 1990, we ultimately were able to work out our concerns there, and we supported that statute, and we've been working hard to implement it. We have,
and I think there's been a good faith effort to implement it. I thank you for that, and other departments who are cooperating.
Right. In the in the civil justice reform package, we contemplate use of ADR more in litigation. As you know, your statute dealt with the administrative process. Now we're looking at trying to give ADR a shot in the arm in litigation. And as you know, the President just put out an executive order where he's really trying to take the lead in this area and require the federal government as a litigator to adopt a lot of these civil justice reforms, including ADR. So now we have the mandate under this executive order to use ADR as much as we can in the civil litigation area, and we intend to do that. It's becoming, with the increased demand that we're placing on our court system, on the criminal side as well as the civil, it's becoming more and more important that we try to discipline the civil side of the docket. And ADR is one of those ways we can relieve the burden on the court and help the court manage its workload better and handle priority cases, including serious criminal prosecutions.
Do you still have any qualms about constitutionality?
I do have qualms about the constitutionality of binding or of delegating to a private party outside the government the power to bind the government in arbitration, but that wasn't implicated in the ADR statute.
Within, I guess I'd ask, within your concerns about constitutionality then, to what extent then would you find yourself supporting and encouraging arbitration efforts if confirmed?
I support arbitration efforts. The problem comes when it's binding on the government with no chance for a senior government official to review it. And that's the way we dealt with it in your statute. There's a 30-day period where a senior government official can review the decision, and then I think that there are incentives against upsetting an arbitration decision. But I looked at this issue in the administrative context. I haven't looked at it yet in the litigation context. I don't know whether the Office of Legal Counsel has. So in a way, I'm talking off the top of my head here about constitutional issues, and I really haven't looked at it that carefully.
Well, beyond the executive order, what do you think we can do to encourage greater use of currently available arbitration procedures?
In litigation?
Yes.
Well, first, I think the President, the federal government litigates 25% of the civil caseload, I believe. So the President has taken a major step by requiring the federal government litigators to make full use of ADR. And as you know, we are trying to push the broader package, including ADR, on the legal profession so that the lawyers generally make greater use of it. And I think that the administration is showing a lot of leadership in that area.
Requiring the loser to pay winners' attorneys' fees, and this is also part of Vice President Quayle's recommendations, following the so-called English rule where that's done. Actually, I guess it's done in almost every place but in America. But what contribution to our civil justice system would the adoption of that English rule make? But more specifically, obviously, it must be viewed by the administration as positive. What do you intend to do to pursue that? That goal, I mean.
We are proposing a modified English rule in a very limited area to basically use diversity. There have been a number of proposals to do away with diversity jurisdiction. And what we're saying is, let's use diversity jurisdiction as a sort of test bed for a modified version of the English rule. And let's see, based on real experience in the federal courts, how it works. The modified version of the English rule has built-in protections against for the little guy, to make sure the little guy isn't driven out of litigation. It also has built-in protections for the contingency fee plaintiff. So I think that the ultimate impact of this, projecting ahead, if we adopted a modified English rule, would be to help the middle-class litigant, the plaintiff, get legal services on meritorious cases where they feel they have a good chance of winning. They will be able to recover their legal fees and be made whole. As you say, we're the only jurisdiction in the world, common law world, that does not have the so-called English rule. So we'd like to see some experimentation in that area.
And you're in a sense saying implicitly that this is a goal you pursue and you're going to pursue for the administration?
It is part of our package. Now, in order to we cannot unilaterally impose the modified English rule. That will require either legislation or rule changes in the federal rules, and going through that process, and we intend to pursue it. We intend to pursue all the recommendations in the civil justice reform package, and would like, frankly, to work with this committee on those ideas and any other ideas to promote civil justice reform. I think steps were taken, I believe it was in 1990, in the civil justice reform package. And I think we can still do more, and I think everyone's interested in doing more. And we've told the ABA and the other elements of the organized bar that we would like to work with them and talk with them about our proposals and any other proposals.
I know that you have more than a passing concern in the application of American legal authority to events occurring abroad, extraterritorial jurisdiction. I'm concerned that American companies are competing on American soil with foreign enterprises that are not subject to the strict limitations on monopolies, cartels, and collusion that our antitrust laws impose. I think it's important that the Antitrust Division actively investigate and prosecute anti-competitive activities by businesses which sell their goods in the United States. American businesses should not have to compete with companies that benefit from an artificially induced absence of competition in their home countries. Do you have any misgivings about strict application of American antitrust principles to foreign countries trading in the United States?
I think we have to move very carefully in applying our antitrust laws extraterritorially because they can have adverse consequences for competition, for American consumers, for our economy, where a foreign government, for example, retaliates or takes action against the United States if we unilaterally apply our antitrust laws to foreign activity. However, I think in the foreign area we are moving on two fronts. First, we are trying through international cooperation to increase antitrust enforcement abroad and to reach a better understanding and a common understanding of competition strategies with European and other countries. and reaching antitrust agreements, cooperative agreements with trading partners to enhance antitrust enforcement overseas. So part of it is cooperation. And I think Jim Rill has been exercising a lot of leadership in that area, and recently in Japan in the Structural Impediments Initiative, we were able, I think, to increase Japanese antitrust enforcement. But we also are taking a look at enforcement of American antitrust law overseas, and we're re-examining that whole issue. The Export Control Act of 1982 provided, I believe, that antitrust laws should apply to foreign practices that substantially and foreseeably affect foreign commerce of the United States. I think the Antitrust Division in 1988 in its international antitrust guidelines tried to back away from that statutory requirement by imposing a limitation on enforcement which says that we would only enforce where there is direct and substantial harm to U.S. consumers. We are re-examining that 1988 limitation and are looking at potentially applying antitrust laws solely where there is impact on U.S. companies, U.S. exporters, without having to show an impact on U.S. consumers. So that would be an attempt to return to the 1982 standard in the statute and change the 1988 antitrust guidelines. That is still under review, but the policy that's being contemplated would include unilateral enforcement in proper cases, subject to considerations of jurisdiction, whether it's an appropriate case under principles of comity. But if the proper case were to arise, if we do go down this road, then we would be bringing unilateral antitrust actions against foreigners who are violating U.S. antitrust laws.
So, in summation, do you see it as a useful tool then to see that American businesses have a level playing field in international competition? As you know, it seems to me to accomplish the same goal some of the suggestions that Vice President Quayle's Commission on Competitiveness is trying to accomplish in other areas.
Antitrust is a very valuable tool, both domestically, it's an essential tool domestically and internationally. And we have to move cautiously internationally because there can be adverse consequences to unilateral action, but we are exploring ratcheting up the use of antitrust laws.
I guess my only admonition is don't fall into the State Department mentality about being so cautious that we continue to lose the battles that we have over a long period of time. I would expect that that in the area of the enforcement of American law that you would have considerable leeway than a lot of other cabinet positions have when dealing in foreign matters, so that the State Department isn't in the end making decisions for the Justice Department like we see them making in the Commerce Department with a special trade representative, with the Agriculture Department, to a great extent even with on foreign tax policy with the Treasury Department. And I just ask you to use every tool you can and be as aggressive as you can in that area. Let me move on, please. I'd like to bring up an issue that would be no surprise. My 15 minutes is up.
Go ahead and ask if you have another question. Okay. Is it a whole line of questioning, Senator?
It would be, but let me ask one question just to get something out now, and then it won't be a line of questioning. It'll just be one question, but it's another area. And that's, you know, I've had an interest in the American Bar Association's role in judicial nominations. They've been involved, as I understand, since 1950 to assist the investigation and assessment of qualification of presidential nominees for the judicial branch. No other private group is allowed to play this quasi-governmental role in the constitutional process, so far as I know. And of course, the Senate has the duty to investigate and assess nominees and does the job quite adequately without the help of the ABA as far as I'm concerned. I'd like to have you state for the record how you see the ABA's role in the President's nomination of and the Senate's advice and consent of candidates for the judiciary.
Well, the ABA plays a unique role, as you pointed out. It is actually brought into the nomination process itself. That is, before the President exercises his responsibility of making a nomination, he is bringing in a private group to help him assess a candidate pre-nomination. And that's a unique role. It's to be distinguished from making recommendations about potential nominees, and it's to be distinguished from rating, that's R-A-T-I-N-G, candidates after they are nominated. I think that if the ABA is using agreed-to standards and is not imposing its own tests or criteria that haven't been agreed to ahead of time and understood by all concerned, including this committee, that role, that can be a constructive and a useful role. Somebody has to do that job. As you know, we've had concerns about it in the past, and we have been watching it very carefully. I'd say over the past year we have pretty much ironed out our differences with the ABA, although it is a role that is subject to abuse. And we will be continuing to watch it very carefully. But at this point, I'm not inclined to make a change.
I understand you're reconsidering your decision to not allow state and municipal bar associations to be involved in the nomination process. If the ABA process has some problems, and I think they do, why would you consider compounding the problem by the involvement of other bar associations in the confirmation process?
Well, as I say, I have no problem with other bar associations making recommendations. I have no problem with other bar associations evaluating people who are nominated. I would have concerns about bringing other bar associations into the pre-nomination process that is now being served by the ABA, playing the role that's now being served by the ABA. Because
well, then my information was probably wrong. You aren't reconsidering.
Well, one of the main objections of other bar associations, at least the objection that they have been most vocal about to me, is the affirmative steps that the department has taken to discourage people from talking to them. They feel that we have blocked their access to people by telling candidates not to talk to other bar associations. And I am taking a look at that issue. But I would be concerned about letting other bar associations into the process as a sanctioned group like the ABA, because I don't know what the standards are that they're applying. I'm not sure where you would draw the line. The ABA is an umbrella group, and I'm not sure where you would draw the line. The process could become extremely burdensome on candidates, and there are enough disincentives right now on public service and serving in the judiciary to open people up to that kind of process. So I'm concerned about letting them into the same way the ABA is, but I am looking at the issue of whether or not the Justice Department should be in the business of affirmatively requiring candidates to not talk to those kinds of associations.
Thank you, Mr. Chairman.
Thank you. Thank you, Senator DeConcini, for your patience.
Thank you, Mr. Chairman. Mr. Barr, you and I have talked about the need for cooperation among law enforcement agencies. As a matter of fact, I just read a speech you made in October 2nd, where one of the things you said, quote, "If there is one thing we have learned about fighting crime, it is that success depends on the essential ingredient, cooperation. And of course, cooperation among law enforcement agencies is what you were referring to. I couldn't agree more. We spoke about this when we visited, and I gave you some examples, such as the problem between the FBI and the ATF over gang investigations, Secret Service and the FBI over financial institutional fraud investigations, which last year you waded in or were involved in finding some compromise. I'll talk about that in a minute. The Customs Service and DEA over Title 21, 881 authority between Treasury and the Justice Department on sharing proceeds. What specific plans do you have, Mr. Barr, to eliminate or reduce this, and are you willing to wade in yourself to see that these are minimized and there's some changes made within all law enforcement so there's more cooperation involving each other?
I couldn't agree more that it's critical that we strengthen cooperation. It is the essential element of any kind of success on the crime front. Strengthen it first among federal agencies. That's our own family. And that not only means interagency, that is Justice and Treasury, but it also means within the Justice Department. We have agencies in the Justice Department who sometimes are getting into turf fights. And I have weighed in to the specific issues that you've just raised, which are mainly Treasury agencies interfacing with justice agencies. My general approach is we can't let turf fights distract us. We have to get on and get the job done in the most effective and efficient way. And as I mentioned to you when we were talking about this earlier, my principal concerns are let's do it in a coordinated way. Let's not just go off on our own and, you know...
Mr. Barr, are you prepared to continue that policy to wade in and, you know, if it so happens that Border Patrol should have has more merit, you know, are you willing to tell the FBI or Treasury or Customs or whoever is working there that, hey, this isn't the way to operate? That's what I'm really looking for.
Absolutely. As you know, I weighed in on the BATF issue, and we worked out a compromise there. I think there was some misunderstanding on the FBI Secret Service issue, but I think that when the smoke cleared, I think you appreciated that.
I'll ask you a question on that, but on the BATF over the gang, you know, Thornburgh wrote a letter opposing that legislation, and that doesn't help much when we're trying to get some compromise, and as a result, we really dropped the whole thing. Although the FBI and your designee came up there and did try to work something out. But let me give you an example. The Secret Service has specific authority under Section 528 to undertake financial institutional fraud investigations through coordination with the Attorney General. And since November 1990, the service has investigated 245 cases of financial institutional fraud through 57 offices throughout the country, and thus far the service has arrested 98 individuals, 48 of which have resulted in felony convictions. And recent Department of Justice reports on financial institutional fraud indicates that the FBI is receiving about 3,000 of these criminal referrals a month. But for the month of July 1991, the latest month for which we have statistics, the FBI only opened 608 cases. This leads me to believe that cases are not being worked due to lack of resources, and here you have the Secret Service willing to provide some of that resources. And that being the case, can you tell me why, since August of '91, the Secret Service has not received any FIF referrals from the FBI?
No, I can't. I'd have to look at those figures and find out more about the situation. However, I will say that when I've traveled around, I've talked directly to the Secret Service people out in the field, and I think I mentioned this to you before, and I've asked, any problems here? And the word I'm getting from the field is that there are no problems, and maybe I'm hitting the wrong jurisdictions. The other thing is, I made it clear to the Secret Service head, John Simpson, who I guess is now leaving, so I'll make it clear to his successor, and made it clear to Pete Nunez, the Assistant Secretary of the Treasury for Enforcement, that if there is any foot dragging or turf fighting in this program, that they're to take it directly to me, and so I can deal with it. And as far as I'm aware, no one has come and complained.
I don't think they have, and I get my information from some of the ones here at headquarters and some of the ones out in the field, and maybe there's a reluctance to bring it there, maybe partly because you weren't confirmed or they didn't know, how to do it. Do you know, does the Department of Justice have a policy instructing its agents not to conduct any FIF cases of under $100,000?
I don't know the answer to that. I do know what I said at a meeting, the sort of the Magna Carta meeting of this concordat between the FBI and the Secret Service, which was that it should be regional decision as to how best to use the resources. If in a particular jurisdiction the best way of using the resources is smaller cases, fine, if that's what the people in the field thinks the best way to use it. In other cases, it could be joint investigations or big cases. I've heard conflicting things from some people in the Secret Service. Some have told me they want a lot of smaller cases to build up the expertise. Some have complained that they're getting the little cases and they're not getting into the big cases. So
I would just hope that you'd look at that
Sure.
After your confirmation. And let me go to the forfeiture fund. Do you support the equitable sharing of proceeds from seized criminal assets with state and local law enforcement? I suspect you do.
Absolutely.
And how about equitable sharing among federal law enforcement bureaus?
Yes, and in fact, we've expanded sharing to other agencies,
including outside the Justice Department.
Oh, we have brought the Postal Service in and believe in it strongly.
Now, do you have any estimates from the DOJ forfeiture fund, how much they received annually based on law enforcement investigations outside the Department of Justice?
How much agencies outside?
Yeah, how much outside have they contributed to the DOJ?
We have those statistics, but I wouldn't know them off the top of my head.
Well, I'm not sure either, but it seems to be safe to say that the IRS alone contributed $100 million plus to it last year. And just for the record, they only received $3 million in sharing of these funds. And our understanding is that roughly there's $500 million in that fund after the so-called expenses of administering that fund is taken out. And the Justice Department had instituted a policy of 15% for your handling it, and 20% of it goes to court. My concern and question is, do you think a better job can be done to get more of this money back to some of these agencies that are outside justice, as well as those that are inside justice, perhaps Border Patrol and others, of this fund?
Yes. The theory originally, and there's some merit to it, is that we shouldn't have a speed trap mentality in the federal government, so that agencies should not feel that just because they seize the money, they're going to get the money. And the theory was that you should have a central allocator and a set of priorities that dole out the money without regard to who brought it in. And I don't think it's been Department, if in fact there has been inequity, it's not Justice Department parochialism. It's the setting of the priorities and just the way the money was spent to meet those priorities. However, I have made it clear to Treasury, and I'll say it here now, that I think I would fully support a regime whereby Treasury agencies get a pro rata share of what they bring into the fund, provided that the Secretary of Treasury dole out that money among Treasury agencies so that they don't have a speed trap mentality over there. If IRS gets the money, so they feel that, they get.
I think that's a good solution, and I hope that you would encourage that, because I think somebody has to make that decision, and I don't trouble too much that maybe I do with Secretary of Treasury because his non-involvement in law enforcement, but somebody's got to make the judgment, and I see your point. And I'm encouraged that you say that there ought to be more sharing outside the department as well as within. I don't know how much portions Border Patrol get, but I suspect it's very little, and I'd like to see that changed. Am I correct in stating that you would have no objections to the establishment of a separate fund for the Treasury Department? but that in your understanding that the objections probably will come from OMB?
I'm not sure about what OMB's position is. I've told Treasury that I would support a separate fund for Treasury if all the rules were the same, so we don't have the unseemly spectacle of government agents running around bidding for local business. But in the course of those discussions, it was my impression, and believe me, these discussions have taken circuitous turns and twists over the months, but it's my impression that Treasury now may feel that they're a lot better off leaving the management to the Department of Justice and just getting the pro rata payout. I don't know if that's still their position, but for a period of time it was their position.
Yes, I've talked to them a number of times, and their position seems to go back and forth on that. I think what they'd really like is the greater sharing of those assets. And I think if that seems to be clearly your policy, and if confirmed, maybe you'll have some time to designate somebody and tell them what you want to see happen there, and I think that would be a great improvement. Let me ask you a couple of questions, Mr. Barr, about the Border Patrol. I've discussed this with you and expressed my frustration about the lack of attention given this critical law enforcement agency. The Justice Department has maintained that Congress has failed to provide the funding necessary to meet authorized staffing levels, and that is just not true. The fact is that funding for Border Patrol has increased 63% since fiscal 1986, due in large part to the efforts of Senator Hollins and Senator Rudman and the Congress who has backed this. And the administration has not been there making these requests. However, despite these increases, GAO found that staffing for the Border Patrol along the southwest border has declined by 9% since 1986, and the attrition rate is 34%, the worst, I think, in all law enforcement, even below the Bureau of Prisons. Now, as Attorney General, do you intend to make the Border Patrol a greater priority within the department, and can you give me your commitment now to see that this important law enforcement agency is given the funds and attention required to carry out its mission?
Absolutely. The Border Patrol is a superb professional organization, and I intend to support it fully. I more generally have tried to support the INS, which I think has suffered from underinvestment for a long period of time, and the Border Patrol is paying the price for that.
Indeed they are.
And
indeed they are. And GAO certainly substantiates just what you said.
I have increased the budget priority of the INS as a whole and the Border Patrol specifically, and I will be seeking more resources for Border Patrol personnel and for investment in their equipment, which, as you know, is old and in
If you
disrepair.
succeed in getting that through OMB or not through OMB but out of Congress, will you do what you can, and you can have a lot to do with it, to see that the INS doesn't sap up for their legitimate needs some of the appropriations that are set aside for the Border Patrol?
Oh, absolutely. I would have to approve any reprogramming of the funds.
Have you ever given some thought of the Border Patrol maybe should not be in Treasury? I realize that's turf and sensitive.
Was that a Freudian slip when you said Treasury?
I mean, injustice, or about it being in Treasury or a separate agency, or at least a separate agency within Treasury where it would not be the problem that you and I have discussed and that you now indicate that you're willing to get into. I don't care where Border Patrol is. What I do care is that they get the short shake of the budget, and have for literally 15 years since I've been here, except 1 year when President Reagan's budget did ask for a substantial increase in the Border Patrol. And to me, that's a disgrace. And my question is not a Freudian slip, it's a direct one. Do you think that Border Patrol, have you ever given a thought that it might be either an independent agency within the Justice Department rather than under IRS or, INS or someplace else?
I've given passing thought to the proposal because I've seen it floated occasionally, but I believe that we can improve INS and the Border Patrol within the Department of Justice. INS is a very difficult agency to manage. It has difficult assignments, sometimes conflicting responsibilities. And in an era of tight resources, it is sometimes not getting the resources it should have. I have spent a lot of time as Deputy Attorney General on INS to help the head of INS upgrade the agency, improve the management, and start rebuilding the infrastructure. And I would intend to continue to do that. If I'm confirmed to be Attorney General, there's an adage that INS has broken more careers at the Department of Justice than any other agency. But I'm willing to take the risk, and if at the end of my time it's a better agency, which I think it will be.
I can tell you, Mr. Barr, you'd be the first Attorney General in the 15 years, almost 15 years that I've been here, that would really pay attention to INS. And every Attorney General I've asked these questions, every Attorney General has more or less said, yes, more should be done. And I must say every Attorney General has not done it. And your immediate predecessor made strong commitments here, and that's water under the bridge, and there's no use going back over it. And I could read you those statements that Mr. Thornburgh said, and there was little or no improvement. As a matter of fact, there's been a denigration towards the Border Patrol. And I'm pleased with your attitude, I must say, and it helps me feel very comfortable in my support for your nomination, that you have a grasp of the INS Border Patrol problem within your own Department of Justice, and it is just as big or bigger than GAO or Senator DeConcini or somebody else may have told you, and you have that understanding. I appreciate it. Detention centers that are under INS need some attention. Basically, the potential human rights violation within those centers, and how you're going to deal with the expanded number of immigrants that are going in there.
Can I say something, Senator?
Yes, please.
You know, the GAO report, we did get, that came down and made a lot of recommendations and pointed out a lot of problems in the INS, and we didn't even wait for it to be finalized before trying to attack those problems. And you may know that I asked Norm Carlson, the former head of the Bureau of Prisons, to come and do his own survey of INS to help identify areas where we can improve it. Now, I know you're talking partly about resources, but there's also management issues there.
I suspect there are great management needs
and
changes there.
You know, Norman Carlson, who I think deserves the respect he has in the community.
Sure does, from this senator.
The bottom line of his report was that the INS people out in the field are doing a terrific job. They're dedicated, they work hard, and by and large, they're getting their job done. And I think they deserve the support of the leadership of the Department of Justice, and they deserve the support of Congress. And I know you, if it wasn't for your appropriations through your fund, then the Border Patrol would be in worse shape than it is now.
Has Mr. Carlson finished that report and recommendations? Is that what it is to you? Or
yes.
Is that available for us to review? If
it wasn't public, but I'd be glad to.
I would just like to see it. I have the greatest respect for that man and what he did as Bureau of Prisons and other things, and maybe there's something that we can learn from that report as well.
Yes.
Thank you. Thank you, Mr. Chairman. Thank you, Mr. Barr.
Thank you very much, Senator. Senator Lee.
Thank you, Mr. Chairman. Mr. Barr, if there is another vacancy on the U.S. Supreme Court, and while you're Attorney General, the President, I just want to make sure the Chairman is listening. There is another one, and you're Attorney General, the President will look to you to make recommendations to him, whoever the best men and women are available for that position. Have you thought in your own mind what kind of criteria you would use if you were asked to make that sort of recommendation to the President?
Not in great depth, but generally the traditional criteria of competence and integrity and a judicial philosophy that's compatible with the President's.
You would want to be able to give the President somebody you would consider the best person possible, I would assume, though, in carrying out your obligations.
Generally, yes, but
well, generally, yes, you wouldn't. You
Well, I'm not sure
you
what
would
you
not be
mean.
giving the worst person to the president.
We very.
I'm not trying to play games. I'm just trying to think what goes through your mind in making a recommendation. Perhaps we can go step back a little bit, take it step by step. You would want to give the best names possible. Is that correct? Within the criteria you just mentioned.
Sure, certainly.
Okay. And how do you determine in your own mind, I'm not asking for names, but how do you determine in your own mind, looking at a person you're going to walk over the Oval Office with and say the President of the United States, in my estimation, this is the best man or woman for the job, or here are the best 3 people for the job, or whatever. What are you looking at?
As I said, I would look first for integrity. I would look for professional competence. I think being a very strong substantive lawyer with strong analytical ability would be paramount for me. And a judicial philosophy that's compatible with the President's philosophy.
The President said that Justice Thomas was the best person for that job, was he?
I believe he was.
The New York Times reported that the White House counsel Boyd and Gray and then Assistant Attorney General Michael Luttig and others had watched Professor Anita Hill testify, realized her testimony is pretty powerful, compelling, and decided that after watching it that, and I quote now the Times, their only course was to pick apart Professor Hill's case, even if this involved a direct attack on her character. The Times further reported the President approved of the effort. The White House assembled a team of lawyers from the White House, from the Justice Department, and the EEOC to amass evidence against her, along with help from Republican Judiciary Committee staffers. Is the New York Times account accurate?
I did not have personal involvement in the in the support for the logistical.
That wasn't my question.
I'm going to answer your question. That in the logistical support for the Thomas confirmation, but I'm confident that the Office of Legal Counsel behaved professionally and properly throughout. I am told, and it's my understanding, that OLC lawyers did not go out proactively to investigate Anita Hill. They didn't conduct their own investigation. My understanding is that OLC lawyers performed the traditional role of lawyers, which was to take the information that was coming in, transcripts, statements, and so forth, and to analyze them. But I'm not aware of an instance where an OLC lawyer affirmatively went out to collect information. I am told that there was one instance where a lawyer from the Office of Legislative Affairs one night was asked by a senator to make a call to try to track down someone who was purported to have some pertinent information, and at the request of the senator placed a call but never got through to that individual. But that is the only instance I'm aware of where a Department of Justice lawyer can be characterized as going out and affirmatively seeking information against Anita Hill.
To reiterate my question, is the New York Times article accurate?
I thought I answered the question, which...
When they said that, quote, their only course, speaking now of Assistant Attorney General and White House counsel, their only course was to pick apart Professor Hill's case, even if this involved a direct attack on her character. Was that decision made? As a Times...
Just a minute. Did you say they say the Republican staff, they mean the committee staff? Is that what you said?
I'm not referring to committee staff now. I'd like to just get this question answered.
Well, I don't know if you said the committee staff. If so, I want to tell you it's untrue.
We have a...
This committee staff did no such thing.
We sometimes have a problem up here that when I ask questions of administration appointees that the answers come from the other side.
I understood you to say
I think Mr. Barr,
committee staff.
and
I'm only interested in that part.
Yeah, okay. The record will speak for itself. I think Mr. Barr, though, is a nominee who is capable of answering for himself and doesn't need somebody else to answer for him. So if I could go back to the basic question. New York Times said, reports that White House counsel Boyd and Gray and Assistant Attorney General and others decided during the day of Professor Anita Hill's testimony that, quote, their only course was to pick apart Professor Hill's case, even if this involved a direct attack on her character. Is that inaccurate?
I don't know.
Okay. Do you know whether, as the Times further reported, that President Bush approved of the effort and that the White House assembled a team of lawyers from the White House, the Justice Department, and the EEOC to amass evidence against Professor Hill?
And that I think I answered. My understanding of OLC's role was to provide support through the process. That support has been given past candidates. It was going on for months before Anita Hill made her allegations, and it continued through those last few days where the committee's deliberations were focusing on Anita Hill's deliberations. But the support was the support that OLC traditionally gives as lawyers. It was not to go out and amass evidence against Anita Hill. There was, as I say, I'm not aware of OLC going out and conducting an investigation to attack the character of Anita Hill.
And getting that evidence?
But I don't think there was anything wrong with putting her allegations to the test in the advise and consent process.
And was that done also with the help of Republican Judiciary Committee staffers?
The who?
With the help of Republican Judiciary Committee staffers. Staffers from the minority side of the Judiciary Committee.
Was what done?
Putting together the same evidence you just talked about, the same facts you just referred to against Professor Hill, or regarding Professor Hill.
I don't know what Republican committee staff did. I know that I am told that OLC lawyers did not conduct their own investigation into Anita Hill.
Did the White House and the Justice Department orchestrate tactics with members of this committee to go after Professor Hill? Did they coordinate, the White House and Justice Department coordinate tactics with members of this committee regarding Professor Hill, if you know?
Well, I assume that departmental lawyers were coordinating with the committee and the committee staff as they do through every nomination. I don't know what you're referring to by tactics.
Well, it was obvious during the hearing that every effort was made to go against Professor Hill's character. We had, according to testimony that came out, the FBI was following whatever she said and then reporting whether there were any differences in what they had heard from earlier interviews, something they did not do with others
I'm told that
they had interviewed.
Excuse me, Senator, I am told that they did monitor Clarence Thomas's testimony, and I'm also told that they made both sets of agents available to the committee.
Well, without going into the FBI reports, you can't. My recollection is somewhat divergent from yours, and I'd be glad to discuss it further with you out of the committee room. What is, in a case like that, what is the Justice Department's role? Is it simply let's find out what is the truth, or is it a case of saying the nominee is the president's nominee, the president is our client, and we will act in effect as an adversary in an adversary role to protect our client?
Well, I think if allegations are made against a administration nominee, the first issue is to try to get to the bottom of the allegations. I think administration has the obligation to make a judgment for itself about the veracity of allegations about a nominee. And if the administration concludes that those allegations are unjustified, I think it's perfectly appropriate for an administration to defend its nominee through the advice and consent process.
How involved does the Justice Department get in that? Do they start involving themselves with tactics, with so-called spin control, PR?
As a prudential matter, I would not have liked to see the department go out and conduct an investigation to impeach the person making allegations. And as I said, I don't think that happened.
Do you think that following the investigation, though, but once the hearing began, did the Justice Department involve itself in efforts to impeach that witness?
Well, as I said, the Office of Legal Counsel performed the normal work of lawyers. That's what the Office of Legal Counsel are. They are lawyers in the administration. They provide support for administration nominees, and I think it was appropriate for them to review the record, to review the transcripts, to review the allegations that were being made and the evidence that was coming in, and point out areas of that required exploration or potential discrepancies. It's part of the truth-finding process. I assume that that's what this committee was trying to do.
And did they spend a great deal of time on that in this case?
Of course. There was a very, well, they spent a great deal of time because, as my recollection, it was a fairly concentrated effort. It was over a matter of a few days, and there were a lot of groups that were performing that function against Clarence Thomas. I don't think it's realistic for the committee to feel that an individual can come out here with that, come up here and you know, not have the support of the administration that's nominating him.
I'll go back into that rather than use up all my time here. We had also news reports which recently revealed that Ed Rogers, who had been a political aide to John Sununu, entered into a $600,000 contract with Sheikh Kamal Adam only weeks after Mr. Rogers left the White House. The Sheikh, as I understand, is the former head of Saudi Arabian intelligence, but the more important thing is he's supposed to have had a major role in the financial corruption that seems to be coming out of BCCI. Now, as I understand it, the Justice Department, and as I go down through these facts, if I'm misstating it from your view, please interrupt me, because I want to make sure we're both look at the same set of facts. The Justice Department claims that Mr. Rogers played no role in arranging a meeting between the Department of Justice and Sheikh Kamal in Cairo, Egypt, where federal prosecutors and Kamal discussed Kamal's role in the BCCI affair. But the meeting did occur soon after Kamal retained Rogers. And Rogers was in Cairo when the meeting occurred. Is that so far purport with what you understand of the facts?
That's my understanding. That's what I've been told.
Now, let me just ask within that context, what issues are raised if you have a high-level White House aide who goes to representing a target of a major Justice Department criminal investigation just weeks after leaving the administration? Are there any special concerns?
There are two principal legal issues. One is, under the law, under the Ethics in Government Act, did Ed Rogers participate in BCCI matters while he was in the government? If he did participate in BCCI matters and then left the government and took on representation in that area, that would implicate the Ethics in Government Act. The second issue would be whether he had any contacts relating to BCCI with his employing agency, the White House. And if he did, before the expiration of the cooling off period. And this second concern would arise regardless of what his exposure to BCCI was previously. It's a separate issue. And if before the cooling off period he had contacts with the White House regarding a particular matter like that, then that would also implicate the Ethics in Government Act.
The cooling off, you mean the revolving door?
The 1-year absolute bar on contacts.
Well, if my time is up, I'll come back to this. I don't want to, I know on the other side they go over time fairly often, but I don't want to go over that. Senator Thurman may be concerned about this line of questioning. I'll hold it for another time.
Well, we've all
Okay, with the chairman have gone over time, and you're entitled to go over the time since everyone has, Democrats as well as Republicans. But Senator Thurman would like to ask a few questions.
Since your time was up, I wanted to ask some questions.
Of course, and I perfectly wanted to wait till my next 2 or 3 rounds.
Mr. Barr, I think one of the most serious domestic problems today is violent crime. There's a murder committed every 22 minutes, a rape every 5 minutes, a robbery every 49 seconds. What do you believe can be done to address the crime problem today in this country?
Well, as I said at the when I was stating my priorities, I think the violent crime problem, while preponderantly a state and local matter, there are areas where the federal government can make a difference. One, obviously, is in prosecuting the drug war, because there is a relationship between drugs and violence. A second would be in attacking criminal organizations, that is gangs, street gangs, many of which are involved in drug trafficking themselves. And I think there's some initiatives we can take in that area. We are focusing OCDEF, the Organized Crime Drug Enforcement Task Forces, more on those kinds of organizations like the Crips and the Bloods. You may have read about the FBI anti-gang squad that was established in Washington, and I think you'll be seeing more of that nationwide. A third area would be attacking, trying to contribute federally to the problem of career criminals, career armed criminals. We have strong firearms statutes under federal law, and we're seeking some additional statutes. We realize that a very high proportion of violent crime is committed by a very small group, a cohort of hardened criminals, career criminals. And we can use the firearms laws to apprehend these individuals and put them away in federal prison for long periods of time. And I think we've launched we've had some success with a program we've launched recently, the Trigger Lock program, where we've now charged since April over 2,200 armed career felons under that statute. I think also we have to focus on strengthening the criminal justice system itself. We've done a lot in the federal system during the 80s, and the federal system is shaping up as a fairly good system, although we think we have some unfinished business. That's what the President's crime bill is all about, so there are some things we can still do at the federal level. But I think the states should start following suit. Some are and have adopted a lot of the reforms, but a lot have lagged behind. And I think the federal government can play a leadership role in encouraging states to adopt the kinds of strong laws like pretrial detention laws and other laws that help reduce violent crime. And then I think the federal government can also promote innovation by investment through the Bureau of Justice Assistance and NIJ in pilot programs and in research.
Thank you very much. I authored some legislation on child pornography and obscenity. And I just wonder what, in your opinion, steps could be taken to eliminate this insidious material?
Well, as you know, the department has created a section in the criminal division that is dedicated to this mission. We've added some personnel to that section, and they're involved nationwide in prosecuting child pornography and other forms of obscenity. And I think that program should continue to be supported.
Mr. Barr, I want to commend you again for your great work on the federal prison facility riot that occurred. And to what extent was this uprising attributable to overcrowding in the federal prison system? And what would you suggest as Attorney General to address the problem?
I don't think it was attributable to generic overcrowding in the prison system. It may have been contributed to some extent in a backup that occurred on the deportation of the Mariel Cubans. That's the group we're talking about. And there were delays caused by Cuban Cuba decision not to accept a particular flight of Mariel Cubans, which backed up the system and meant that there were more Cubans in that particular facility than there should have been at that time. And that may have contributed to some extent to it, but I'm not sure that maybe the magnitude of the crisis, but I'm not sure that the crisis would not have occurred anyway.
I want to ask you this. I've been a long-time proponent of joint multi-state and local organized crime and narcotics projects known as Regional Information Sharing System, better known as RIS, RISS. I believe they perform a valuable service to both state and local law enforcement agencies. The Regional Organized Crime Information Center, that's the ROCIC, I think it's done a fine job. Do you have any plans to expand that or to improve it in any way?
Well, I believe RIS is essential. Those are the regional information sharing systems that there's 6 regional systems that have been set up in the United States to help local law enforcement coordinate their activity interstate. As you know, the administration, having set up this system, would now like to see the states pay for them, their continued operation, and has sought to basically zero out the federal contribution to the program, but that has not found favor on Capitol Hill. So last year, the federal government continued investing in it. I think it was about close to $15 million. But regardless of who should pay for it, it's an important system, and it must continue. Clearly, it's in no danger of being zeroed out right now.
I'm glad to hear you say that. There's a vote on now, Mr. Chairman. I guess we'll have to go. Mr. Barr, I want to congratulate you on your record so far. You've done a fine job. We're proud of you. And I hope we can confirm you forthwith, and I think you make one of the finest attorney generals this country's had.
Thank you, Senator.
Thank you. Mr. Barr, as you can see, we're about roughly halfway through the process in the first round. As I indicated to you, it's likely that there will be a number of questions on BCCI, many of them, most of them, if not all of them, generic. There is a, if not a dissatisfaction, a disquiet in some quarters in the Senate with the depth and speed and thoroughness of the Justice Department's activities thus far. So I expect you'll be asked more questions than that tomorrow. And I'd also like to, tomorrow, as I indicated to you, talk with you about separation of powers issues. And, I appreciate you taking the time today. We'll reconvene tomorrow at 10 o'clock and hopefully move along swiftly. All right?
Thank you, Senator.
Recess tomorrow at 10.
Hey.
You all right with me? You know that. I know it. All the down still in the malt box. Yeah, thanks. I ain't got to do. Well, I ain't got to do. Yeah. You do have